So I'm going to read a statement. Jim Griffin will have a couple words to say, and then we'll answer questions. Today, Jim Griffin and I filed a petition based on newly discovered evidence with the South Carolina Court of Appeals to stay Alec Murdaugh's appeal while a hearing is held on a motion for a new trial. Concurrently, we've sent a request to the South Carolina U.S. Attorney to open a federal investigation into the violation of Alec Murdaugh's civil rights. The allegations in the petition filed today speak for themselves, but we believe they explain a number of peculiarities in the 6-week trial. We request that SWED stand down on initiating any investigation of these allegations since they are heavily invested in maintaining Alec's convictions. We suggest they wait for the Court of Appeals to rule and receive direction from the trial court. If the Court of Appeals remands the case for an evidentiary hearing, if the Court of Appeals remands the case for an evidentiary hearing, we would also request that those in the media and the public respect the privacy of those included in this filing. Jim and I want to thank those on our team who stand behind us and have worked tirelessly to ferret out the truth. Alec Murdaugh maintained and still maintains his innocence in the murder of Maggie and Paul and believes the truth will ultimately prevail. Jim?
The right to a jury trial, is a fundamental principle of our justice system. Jurors must be free from outside influences and must decide the case solely on the evidence presented in the courtroom, subject to the rules of evidence, subject to the rules of the court, and most importantly, subject to the crucible of cross-examination that's guaranteed by the Sixth Amendment to the Constitution, and that is the right to confront witnesses. When jurors receive private communications outside the confines of a public courtroom, the Sixth Amendment is violated and numerous other constitutional rights are violated. And that's not Jim Griffin on the law. That is the law of the land. And I want to quote from a decision from the South Carolina Court of Appeals, which is behind me, and states this: where there is a private communication of a court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. What we had filed today, supported by sworn testimony of jurors, is that the clerk of court had improper private communications with the jurors, and the subject matter of those communications was the credibility of the defense that the Murdaugh legal defense team put up, and it was the believability of the defendant's own testimony. Now, there's been a lot of talked about whether Alec should have taken the stand. I can assure you, when we considered what factors and what we should and should not do and considered whether he should take the stand, we never considered the likelihood, as reported to us by the jurors, that the clerk of court would go in to the sanctity of the jury room before he testified and tell the jurors, don't be fooled by his testimony, watch out for his body language. And that is what the sworn testimony that we have filed in court today says. And if that is true, which we have every reason to believe that it is, and no reason to believe that it's not, there's no choice but the courts to grant a new trial.
Thank you. Any questions? No?
No.
Okay.
When the fourth person was pulled away at those cells, did you guys see that, or did you find out after the fact?
Well, I think we observed it. We did. No, I was there.
Oh, yeah, you're right.
Yeah. I was there. I watched it. But, I mean, look, we were not looking to impute any nefarious conduct. But clearly what the jurors reported to us, that they were off talking, the forelady and the clerk. I saw them together, but, I wasn't watching. Look, I've been doing this almost 50 years. The bedrock of any trial, and I've done hundreds of them, is that the clerk of court is the person that makes sure the jury gets their food. If they're put up for the night, someplace to stay, Their travel accommodations are met. They're not someone that ever should talk to them about the case. I've never had it happen. Again, I've been doing this for a very long time. Never heard of it happening until this case.
And one thing we want everyone to understand, that the clerk of court is an elected official by the people, not appointed by the judge, not appointed by the judiciary. It's a public official who's elected and is an independent state actor. And so that what we're complaining about in the motion that we filed today is the conduct of an elected official, not conduct by Judge Newman or anybody in the unified court system.
And I think it's important also to understand that she is a state actor, and that's why we forwarded today a letter to the U.S. Attorney asking them to open an investigation into the violation of Alec Murdaugh's civil rights by a state actor under color of state law.
I believe you guys had 4 jurors that you had affidavits for in the paperwork you filed. Did they reach out to you, or did you guys reach out to them?
Well, this is an interesting story. Let Jim tell you.
So immediately in the aftermath of the verdict, we had received information that we needed to look into what happened in the jury room. We started down that road, and we met a zone of silence. No jurors would speak to us. And so we were, what I like to call, we were given the Heisman, right? And then when the clerk of court wrote her book, published her book, that zone of silence collapsed. And jurors were upset about that, the ones we talked with, and they were more than willing to come forward and tell us the things that we had sort of heard through a whisper campaign. But, and so as a result of that, we were able to interview some jurors. Now, there's still a number of jurors who maintain that zone of silence, who have not talked to us. We did try to reach out to most all of them that we could get in touch with, but the information we got, I can tell you, was independent of each juror. The first juror we talked to, we got information about Ms. Hill saying, "Don't be fooled." And then the second juror, independent of the first juror, says the same thing, and the third juror, independent of the other two, say the same thing. And so we're very confident that the information is accurate.
Well,
and expectation timeline.
What
a ruling will be? How fast do you want?
Ask them. I mean, we don't have any control over that. We just did receive a notice from the Court of Appeals that the Attorney General has 10 days to respond to our motion. Okay. Now, I think what's interesting to me, again, having done this for so long, is that once we had that initial contact with that first juror, we began going around. We had a list and knocking on, literally on Sundays, knocking on jurors' doors, asking them to speak with us. Some of them wouldn't come out. Some of us told us never to come back. But some did, and some talked to us. I'll give you an example. And one of the things we heard was, once the jury went out, even though there were 6 smokers and they were given smoke breaks during the entire trial, once the jury went out, they were told no more smoke breaks. No, you people that want nicotine, you're going to have to get a verdict first. I mean, it's that kind of stuff. Now that indicates something, and the court would be the one to communicate that. Why? So a bunch of folks told us stuff that appeared to be inconsequential, but in the total context indicated to us that what we've put in this petition about the clerk is credible, and based on sworn testimony from 2 jurors, and we interviewed a third. My paralegal, Holly Miller, has given you an affidavit, or filed an affidavit on what she told us. A lot of these folks just don't want to get involved, but they're going to be involved if we get a hearing, because each and every one of them is going to have to testify in an open court before you as to what happened and what didn't happen. Wait, one at a time. Who?
It would appear that Judge Newman was at least aware of some of the allegations that you talked about in your motion. For example, the Facebook post with juror 785, and the judge actually said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and happening to me."
Well, and that's a good point. There's no suggestion that the judge did anything untoward. But what that does do, if it comes back, he may end up being a witness. So, I mean, but until the Court of Appeals acts, that issue does not have to be dealt with.
But if the fact is that the court was aware of some of these issues but still didn't intervene, how concerned are you?
We don't know. We don't know that he didn't intervene. That's what I'm saying. He's a witness. We need to
You
know.
feel that this evidence is strong enough such that it could have changed the verdict had it been introduced in trial.
You know, that's not the legal test. The legal test is the subject matter prejudicial to the defense. It's not would it have made a difference in the outcome. Was the subject matter of the improper private conversation material to the defense? If it's immaterial, like what do you want to have for dinner? You know, do you want to take a smoke break? Do you want to go home? Those are immaterial matters. But when the subject matter is and is reported under oath by these jurors, it was a direction on how you should receive Alec Murdaugh's testimony. You should look at him. Don't be fooled by him. That subject matter is absolutely material. That's the core of our defense. And that is something that we had no chance to defend against. And so we strongly believe if that evidence is accurate, and the law will require a new trial.
If
So
this
when
is
was
all
the
true,
last
do
time
you
you
think the
spoke with
clerk
your
should be
client?
criminally charged?
When was the last
No
time
comment.
you spoke with your client, and what has he shared with you with his latest motion?
Well, I can't talk about attorney-client privilege information. I can tell you that when I shared with him the affidavits, he's a lawyer. He was astonished. He was shaking. He was in disbelief, and he thanked Mr. Harpootlian, Mr. Barber, and myself for spending our weekends on dirt roads in Colleton County.
And by the way, we've seen more of Colleton County on dirt roads, in places we're city boys, we didn't believe existed in this state, looking for folks that would talk to us. A lot of doors slammed in our face. A lot of doors slammed in our faces.
You think Ms. Hill should still have her job?
I'm sorry?
You think Ms. Hill should still have her job?
No comment. I'm sorry, what?
Facebook posting from the ex-husband of the dismissed juror. There's a lot of detail in there about that. And there's some in-camera transcripts there as well. Was this not something that he handled very quickly? I mean, the fact that you guys are alleging it didn't exist at all and perhaps was conspired to be created to get this juror dismissed?
Yes.
I mean, that's a very serious allegation.
It's all serious. Everything we've alleged, everything in those affidavits is serious. This is a very serious matter. And again,
So what you see in the sworn testimony that's been filed today is Ms. Hill told the court that there was a Facebook post by this juror's ex-husband. The ex-husband has filed an affidavit saying, "I've never posted a Facebook post." Ms. Hill in her office says he must have deleted it. We can't find it. But they produced a Facebook post from someone with the same name apologizing for an earlier Facebook post and that Satan made him do it and et cetera, et cetera. And Ms. Hill related that as being this juror's ex-husband. Ms. Hill had this juror's ex-husband's photograph. You can match them up. They don't match. And what we do know, and we laid it out in detail in our brief, is that the apology Facebook post was posted, I think, on February 16th and said we had deleted it the day before, February 15th. Ms. Hill is telling Judge Newman on February 23rd that I just saw this Facebook post. Impossible. Impossible. We also have in there sworn testimony that Ms. Hill told this juror that SLED went out and confirmed with your ex-husband that he posted that. Not true, according to the sworn testimony.
and Phil Barber and I and Howie Miller from my office went down and interviewed the ex-husband, and he allowed us to, I wouldn't know how to do it, but Phil did, to download his entire Facebook history. None of that is in there. So, I mean, again, we've done what we can do. We're not the police. You know, we have no way to compel anybody to talk to us or give us anything. We've asked very nicely. Now, I will say this. The two jurors that gave affidavits have an attorney, Joe McCullough, who was skulking around here a moment ago back there. So if you want to know about those two jurors, you may want to have a chat with him.
What's the motivation of the jurors talking to you?
Wait, what?
What's the motivation, do you think, of the jurors talking to you? Are they upset with the clerk?
I think they were upset with the way things went. And the clerk, I think they may very well, yes, they're upset with the clerk. They're upset with the way this played out.
Are they regretting their vote?
Can't comment on that.
The Facebook post, the person who posted the original post, have you ever gotten an opportunity to speak with them? And if so,
No. I mean, the original post, we don't know whether it ever existed.
But the apology post, did you speak with him, Phil?
No,
Did we speak?
no, we did not speak.
Do you have a timeline from the FBI regarding your request for your investigation?
Well, as you know, having talked to the FBI before, no. They're not going to tell us anything.
In your letter to the U.S. Attorney, you mentioned the importance of having the FBI investigate as opposed to SLED, for example. Can you talk about the importance of having the FBI get involved?
Well, having anybody but SLED investigate it. SLED is very invested in this conviction. How invested? Well, the agent, David Owens, that testified under cross-examination by Jim, admitted two things. One, he perjured himself in front of the grand jury. And two, he fabricated evidence. SLED made him this year's Law Enforcement Officer of the Year. So is that the agency that ought to be going to jurors? I don't think so. I think that the court, if this is remanded back, the trial court should pick somebody else. If the FBI is not doing it, then there's the sheriff's departments, there are other folk, not Colleton County, but other sheriff's departments that they could go out and interview jurors or bring them to court. I mean, all these jurors are going to end up testifying anyway. There may not be any reason to go out and interview them. They may just put a subpoena on them, bring them to court.
How important is it for y'all to get these jurors to testify under oath in a place where, like you say, the zone of silence when they have to talk to y'all?
Go ahead.
Yeah, I mean, that's something that would happen if we get the hearing that we've requested. That's why we've requested the hearing, so that we can get come to court, jurors come to court, witnesses come to court, but subpoena records, phone records, for example, emails, for example. I mean, so with a hearing, we have a broad array of assets at our disposal to bring evidence to court. Right now, we've got nothing except Dick's Mercedes and dirt roads in Colleton County.
And has there been any jurors who refute what the other jurors are saying?
No, we've not had any juror contradict anything what the other jurors are saying. What you, Jen, what you saw in some of the affidavits is the jurors were separated in two rooms and sort of broke up from, guys in one room, gals in another room. I don't know if that was appropriate. Men in one room, females in another room. And so the comments that we've gotten on the sworn affidavits come from the ladies' room, if you will, more so than the men's room. But we do have information that we submitted from one juror where he does acknowledge that she talked to him about evidence, about autopsy photos, and don't be upset about them. I mean, that should not be happening. That should not be happening. And this juror is a smoker, and he relayed to us basically the coercive effect of people who have a nicotine habit not able to smoke
Until they reach a verdict.
And so that's what we got.
Wait a second. Yeah.
An issue with the cable at the very, could you read that, there is an additional motion real fast, that issue. You sent
Do what now?
The motion you read, can you read that? The very first thing, I didn't.
Yeah, I mean, I'll read it for you after we get done with this, but I don't think I ought to keep all these folks doing that.
Or would you request a change of venue?
Well, you got to get a new trial before you get there, and that's not something we're going to talk about today. And yes, ma'am.
The activities that the jurors have given the affidavits for, was that behavior that you believe Ms. Hill was exhibiting to all 12 at one time? Or were they singled out or segregated?
Well, we know some of the statements were made in front of the jurors in the one jury room. Now, understand I think there are only 6 jurors in that room, or maybe 8. I'm not sure, but not all the jurors would have been present for all the statements. Clearly, they were given in one room or the other.
And just to be clear, the catalyst for reinvestigating this was the publication of the book.
Yes, ma'am.
So,
Go ahead.
So we didn't stop investigating, but we were hitting brick walls until her book came out, and then jurors who obviously were not comfortable with how she handled matters were even less comfortable with her going on a book tour and making money off what she did. That's what was reported to us.
Now, she has said her book is self-published. That really
I'll send you a link, Larry. I'll send you a link.
stated that somebody said, well, she's self-published.
Well, she's trying to make a lot of money. That's the point. I mean, she's trying to make money off of it. She's selling the book. I mean, the question is, was it a successful scheme? I don't know. I mean, what if you've read it? I'm not going to give a book review here, but I don't know that you buy the book. I mean, it's not well written. The story she tells is not accurate, in our opinion, at least the facts as we saw them.
What did you think about the passage of the book that describes going to Moselle with the jurors?
Well, the problem I have with what she says in there is, after going to Moselle, we, if you notice, she used the plural we, felt such and such and such and such. Is that the jurors and her? I mean, I think that's great cross-examination for her when she testifies in this matter before the trial judge, if the Court of Appeals sends it back.
Do you want any hearing in this matter to be public?
Absolutely. Absolutely. Want all y'all there. We miss you. Any other questions?
Yeah, you said you're investigating. So along your investigations into the alleged jury misconduct and these allegations, have you uncovered any additional things that you would present in a second trial for your defense?
Let's not talk about that.
Yeah, no. If we are lucky enough to get a second trial, you have to wait and see. We're not going to disclose any of that today.
What is your optimism for getting for this motion?
I'm very optimistic that ultimately.
Hi, Larry. Have you ever heard of anything like this?
Not to this extent, no.
I mean, I've heard and rumors and stuff like that not by clerks, but by some of the personnel trying to do stuff, but always shut down or removed before anything actually happened. But this, I don't know what to say. The elected clerk trying to influence and possibly manufacturing evidence to get jurors off the jury.
She allegedly manipulated the jurors, basically telling them what to believe, what not to believe, like ignore the evidence, ignore the rules of law, ignore the facts, listen to me. I am the trustworthy source. Are you fucking kidding me? I mean,
I don't know how this cannot be a new trial.
Yeah.
Because the judge needs to cover his ass. So, and this is filed in the same courtroom. I would be surprised beyond recognition if this doesn't get him a new trial. And I would assume they would try to transfer it out of county to a new judge.
Or get a special judge.
Yeah.
No, man, this is, and here's the scariest part of it all. James and I both met Becky. Like, we physically interacted with her. We were, I mean, she's like one of the nicest people I've met in a long time. Granted, it is like, rural country, blah, 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 fine, whatever. But it's like the hospitality, like you get the Southern hospitality in South Carolina, in whatever it's called. It's a C. The county name starts with a C. I can't remember it off the top of my head. But if she did what they're alleging, and from what I understand, there's at least 3, if not 4 violations here. Number one, do you remember the story about her giving, one of the jurors was like, gave eggs?
The egg lady.
The egg lady.
Yeah, who was
so
removed.
That was all fabricated. That was all Becky orchestrating it. Number one. Number two, she knew that some of the jurors were smokers, and she said, if you go to deliberate, there'll be no smoke breaks. So basically already intervening in this is right there by itself is already enough. But she went further. She, number 3, said, do not believe the defense. The defense is not reliable. They're lying to you, blah, blah, blah.
Yeah.
And
before Murdaugh, Alec went on the stand, in the break before, she went to the jury room to tell some of them, one or more of them, watch out check the body language. The defense will try to throw you off. And don't believe. I mean, this is. I mean, and as Puri said earlier, that this is not about will it influence the verdict. This is about could it influence their case, and it clearly did. And I have this on the top of my chat. This is not about if you believe Murdaugh did it or not. It is
Correct.
about the process. If we
Correct.
don't give basic civil rights to the absolute worst of them, we can't guarantee it for the actually innocent. So this is as basic as you can get. She did it because she had a book deal coming up. She released her book in July.
Is that what it was? I did not know
Yeah.
this.
And she has been on talk shows. She has been on interviews.
Becky.
Yeah. And
What the I'm sorry. Okay, pause. Time out. What the fuck is the clerk of court writing about?
Let's see here.
Has anybody read her book? Because I have not.
Uh,
I didn't
Here
even
it
know
is.
that there was like a book clerk of court, right? It's like the Johnny Depp trial, and you're gonna have the stenographer write a book about her experiences. Like, who fucking cares? No offense, what's her name? Not Jillian, I forget her name. She's lovely. I love her to pieces. She's the sweetest lady ever. But I don't give a shit what she has to say because it's not going to be interesting. No offense.
Yeah. But there it is. Behind the Doors of Justice, the Murdaugh murders. That's her book.
Behind the Doors of Justice. So okay, so hold on. Let's take a step back because I'm just finding all this out literally like in the last 10 minutes would be an exaggeration. Like that's how fresh this is all for my ears. Okay, so her book comes out, people start reading it, and how do they deduce the jury tampering? Do the jurors start coming forward? What happened?
Yeah, what happened according to the defense is that they were trying to conduct jury interviews, stonewalled completely until the book came out. All of a sudden, they started to get return calls, and jurors independently of each other told the same things. She talked to them. She made instructions. She told them, don't believe. And then the egg lady with a Facebook post that got her removed because her ex-husband had a Facebook post. There was no Facebook post. Never was, apparently. And the apology post that Becky then showed the judge, probably manufactured, because the photo of that guy on that apology post was not of her ex-husband. It was by someone with the same name. I mean, and I listened in on the law, even the law and crime commentators are going, not the chat, but the commentators are saying, if they could give any advice to her, is to plead the fifth.
I agree 100%. But if this is true, and I think where you got me right now is jurors coming forward and independently of each other telling the same story, that's it. That is it right there. If that's a fact, it's over.
Yeah. And I have this, one of the sworn affidavits. Sworn.
I was juror number 630 in the case of Towards the end of the trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled, quote unquote, by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also instructed. Oh my God. Instructed the jury. Sorry, it's crawling under my skin, these words.
Yeah.
Instructed only the judge, by the way, chat, in case while you're wondering what's so important, only a judge can instruct the jury. The clerk of court has no business doing that. The jury watch him closely immediately before he testified because, excuse me, including look at his actions, look at his movements, which I understood to mean that he was guilty.
Oh, let's see if there is. Yeah, this is not the entirety because I don't have the.
That's okay. I get the. Oh wait, no. Well, 6. There we go. But right before the defense put their case, Ms. Hill told the jurors, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." So ignore the evidence that put on by the defense. Only focus on the evidence put on by the prosecution. A one-sided case. After Alex testified, the jurors indicated did not believe his testimony. Oh my God.
Yeah. Yeah. I mean, this is. And this is, as I understand from the things I read, this is criminal actions by her.
100%. No, this is witness tampering. Well, juror tampering, which actually I think is worse than witness tampering. Oh, these 100%. These are all felonies, no question.
Yeah, and she is for profit because of book deal. There are so many charges here within this. It's, I mean,
she walked away clean. She was clean. She was out. She was good until she decides to profit from it, and then everybody decided to rip her head off. Which is...
but from what I read, she had the book deal signed before the end of the trial.
So you think she was acting to like make it spicier?
Yeah, or just making sure it was a guilty verdict, because without it, nobody's interested in her book.
Yeah. Yep. Exactly. Book is not going to make money.
Wow.
Yeah,
but and I don't how the trial went. I'm not surprised over the guilty verdict because there was so much garbage thrown into it. So the jury didn't notice that his car, his phone, and Maggie's phone didn't actually match up. Which was, I mean, you can have 99 circumstantial evidence that is excellent, but if there's one that says they were half a mile apart, then the charges was that he did it by himself, all by himself. If there is evidence in there that her phone moved and his car and phone moved half a mile apart, that's, in my opinion, at least, that's I can't get away from it. That's beyond reasonable doubt.
Yeah.
Not beyond a reasonable doubt. Sorry.
No, I sorry. Yeah, I understood what you meant. I was just nodding because I agree with you.
Yeah. And I would assume, I know the defense doesn't. They need a new trial. I hope they will get one. I would be surprised if they don't get one. But I would assume, as we talked earlier, somewhere else or a special judge. But how do you find a jury in that county that is either unbiased or at least can go from he's innocent unless proven guilty?
Because every single one of them is going to know about the story if they don't already know about the story. Because it's a small town, everybody talks.
Yeah,
it's possible that all that information already leaked. You're right. You're right.
And nobody. Yeah, I mean, I can't see any chance of him getting a fair trial in that county. He will have a hard time getting a fair trial anyway. But then again, there are a lot of people out there who never follows trials and trial streams or so, and have never heard about him. And even in South Carolina, there are a lot of people who never follows trials. Yeah. And thank you, Flux. I guess we know how they got to the guilty verdict when the phone timeline didn't make sense.
Yep. I was I don't know if any of your chat was in my chat when we were watching the verdict come down. Danny and Direct was with me. We were watching it simultaneously. You guys can go back and see my reaction. It's on my channel. we were both floored. We were just like,
Yeah.
like disbelief.
Mm.
Are you kidding me? How
Mm.
is this possible? We were in a minority. I remember there were a lot of people that actually, I think, even unsubscribed from my channel because
Yeah.
they were like, why is DUI guy supporting this murderer and like calling the judge all sorts of like he didn't do these things right.
Mm.
They were
Yeah.
very much upset with me, and fucking hell, we were right.
Yeah. And this, I believe, is the difference between we who actually have a degree and work with it, who knows evidence evaluation, and layman persons. You have this pile of,
I
look
mean,
what a garbage person he is.
I don't want to chalk it up to that too much because so many times I've had like trials of my own where I'm like, oh, this is a slam dunk, and the jury comes back guilty, and I'm like,
did you
okay.
exchange from another courtroom? Yeah, I've seen that happen before as well, and but sometimes it happens, and I understand why a jury would get there, because he is genuinely probably one of the worst persons in Iowa.
Yeah.
When it comes to scamming people, scamming cripples. I know that's not the politically correct word, but I'm Swedish. Work with it. I mean, he scammed everybody and his mother and their everything alive. He scammed, and on one occasion, probably someone who wasn't. So he is a genuinely bad guy. But he would have, no matter the verdict in this trial, he will be spending the rest of his life in prison. What's unnerving is that it might be one or two killers out there who got away with it. Because
That's
nobody
terrifying.
in that county is investigating this anymore. Right. Thank you, Unhung Hero, for $10. Even more ammo for another look into the Zachariah Anderson trial. Yes. How does the jury reach guilty verdict without some sort of misconduct? Well, the Zachariah Anderson case is even more unbelievable to me, how they reached a guilty verdict, than the Murdaugh. Because, yeah. And there is a guy out there, he calls himself Law Kong, who described Guterres Union's front door. Lots of blood spatter all over it. That door was inches away from the apartment complex mailboxes. On the 18th, which was a Monday, normal mail delivery day. So everybody in that apartment complex collected their mail inches from the front door, and nobody noticed blood. That sounds weird. Now, of course, if you're collecting your mail, you might zone in on it and not notice it, but not the mailman, nobody there. It was in the height of the pandemic. You have food deliveries, and nobody saw anything on that door on the 18th. All of a sudden, when you add up things. So I didn't think about that until he made that. And he's a really small channel, less than 100 subscribers. But he has some really interesting facts, or at least theories around it, that it's good to hear. But this is the Murdaugh-trial, and yeah, it's. I have a few more questions. So the whole old jury could now be called as witnesses, not in front of another jury, but in front of the judge. There will, I would assume, there will be a hearing about this.
100%. There's no way that the defense is they're gonna scream until they get one. That's what I would do.
Yeah. And she wrote a book. Yeah, we just saw it. Valhalla. How many times has this clerk done this in the past? I don't think.
That's a good question.
Well, it is a good question, but
I don't think
with
she
the
was
book
involved.
deal and stuff.
Yeah,
book deal,
it's the book deal that
everything.
really sealed it.
Yeah.
Yeah.
She
Personal
had
invested interest.
Yeah. Follow the money.
Yep.
money does, yeah. And the ghost says this clerk should be arrested immediately. That might not be out of the region of possibilities, actually. But then, who will do the arrest? This county's law enforcement? Yeah. And the jury is the little lady that got booted right at the end, right? Yeah. Amateur iconoclast corruption at SLED. Say it ain't so. Yeah. We heard a lot about that, especially that SLED agent who testified in front of the grand jury that we found blood on his shirt. And when in reality, the testing hadn't even begun. I mean, yeah.
Can I share something on your screen?
Yeah, you should.
I am pulling it up right now. Should be. Can you see that?
Oh, there it is. Yeah.
The
let's
2012 was the last time it was updated. South Carolina Code of Laws, Title 16, Crimes and Offenses, Chapter 9, Offenses Against Public Justice, Section 169-340, Intimidation of court officials, jurors, or witnesses. It is unlawful for a person. It is unlawful for a person by threat or force. So now this is going to be a question of law if she does get charged officially. This is just one statute I pulled up. I don't know if this is the only one. But a threat or force to, 1, intimidate or impede a judge, magistrate, juror, witness, or potential juror or witness, arbiter, commissioner, or member of the commission in the discharge of their duty, or destroy, impede, or attempt to obstruct or impede the administration of justice in any court. A person who violates the provision of subsection A is guilty of a felony and upon conviction must be fined not more than $10,000 or imprisoned not more than 10 years.
or both.
Or
Yeah.
both. Sorry.
And
yes.
and then threat or force. Now we are getting into what are the meanings of those words, because meanings in the dictionary and meanings in the courthouse is two different things. Threat, you have the smoking, you're not allowed to smoke. Force, well, that depends. Could you interpret force as in she forced herself into the jury room? Now, she was allowed in there, but not allowed to speak to the jurors, other than here's the food, here's the schedule. So that is what does a court of law in South Carolina considers threat or force. But that is up to, I assume, the FBI or anybody else.
Well, there may be a definition section. I don't know. Let me see if I can pull it up here. No, that's just the universal citation. These codes. Let's see if there's something else. It was 340, same one. Maybe there may be some related statutes. Perjury, no, that doesn't sound right. Jury duty. We may be able to look at South Carolina Code 16.9 in general. Maybe we can find it there. Okay, here we go. So this is the entirety. I know it's probably too small. You guys can't see it. I apologize. I just pulled it up in another tab. But this is the entire article. It covers anything from... It's offenses against public justice.
Mm-hmm.
So if you look at... If we just isolate the word jury, see where it comes up. Most of it, this is perjury, perjury, perjury. Okay, here it is. So we were just reading section 340. Intimidation. Here we go. Attempting to influence jurors by written or oral communication. Now, this seems a little bit more on point.
Mm-hmm.
This is 69-350. Communications authorized by court, not prohibited. Any person who attempts personally or through a third party to influence the action or decision of a grand or pettit juror, which is what we're dealing with in the legal realm, is called a pettit jury, of any court in the state or any prospective juror upon any issue or matter which is or may be pending before such juror or before the jury of which he or she may become a member, by writing or sending him any written communication or making any oral communication, yes, relating to such issue or matter, shall be deemed guilty of a misdemeanor. So now it's not a felony anymore, it's a misdemeanor. Conviction shall be, upon conviction, shall be fined not more than $500 or imprisoned not more than 6 months, or both.
Okay.
Hmm.
But then you have this, she's an elected official. If that is accounted for, because it's a difference if somebody shouting from the courtroom and a person they actually trust as the court clerk, elected official, she is between the judge and the jury. She's the voice of the judge. They would assume that she is speaking on behalf of the judge. So is it a reach that it might be impersonation?
I wouldn't say impersonation, but she definitely has a lot more weight. Like her words when she speaks have a lot more weight than if it was just like one of the bailiffs or something like that, because she sits next to the judge. She's the one who brings the Bible when a witness, right before they testify, to swear on the Bible. She has a lot of power in that courtroom. She has authority. She's like the judge's right-hand woman.
Yeah. And what there must be a code of conduct for such a person.
Oh, most definitely.
She swore an oath to enter office. So in that oath, it must be language that says, don't do this, don't do this, don't do this, on the foot of the Holy Bible. I don't know. But I would assume that they're breaking that oath. Yeah, I'm just speculating here. But if she's in breach of that oath, will it, as an elected official, is it still misdemeanor or does it reach felony? I don't know. I'm just speculating wildly here, but this is just because this is on the very foundation on Western so-called democratic countries. This is the foundation of the judicial system.
Yes.
And thank you, John Basinger. I never got past how Murdaugh had a bum knee, but somehow went back and forth on foot, showered, changed clothes, and left no blood in 11 minutes or less. Yeah, but there was a lot of insinuations and implications. Yeah, that trial should have been 2 weeks long, tops. And it became a 6-week trial, mostly about scams and fraud. And I'm convinced beyond reasonable doubt he's a scumbag. I'm not convinced he actually, at least not that he actually committed it by himself.
Oh, yeah, no, I think we can all agree, and I think I made this point during the trial. Is he a dirtbag, a scumbag, a liar, a thief? Sure, he's all of those things. Freely admitted, probably going to be convicted, but does that make you a murderer?
Yeah.
And the answer is not without the evidence. And I did not see enough evidence when I was watching the trial beyond a reasonable doubt. Again, the key, beyond a reasonable doubt, the discrepancies in the evidence, the inability to paint a concrete timeline to show beyond a reasonable doubt that he committed the crimes. I mean, the most damning piece of evidence that they had was the Snapchat video. And allegedly that was, puts him at the scene of the crime when he said he wasn't there. Okay, so he lied
Yeah.
about where he was. Sure, that is very, very damning.
Mm.
Is it
Yeah.
enough? Is he going to get reconvicted? You know, if it happens, it happens. I will believe
Mm.
and I will trust the jury's decision. But now, as it sits here today, this is completely unacceptable.
Mm.
And he deserves a new trial to be refound guilty. Again, do it. Fine, whatever. But he deserves a new trial because this jury has been tainted.
Yeah, and I often say this at the beginning of a new trial stream, that I listen to the prosecution's opening statement. That leaves me with a lot of questions about, okay, thank you. Now prove it. And throughout their case in chief, they should answer every single one of my questions until a few of my unreasonable questions are left. That's their job. But if there are two left, okay, let's listen to the defense. Maybe they will clear up these questions or bring back up more questions. And this trial, I was left with, after the case in chief, okay, I believe he's a scumbag. But I listened to this cell phone data evidence, which was mumbled at best, so to speak, and I didn't get there. And then it was the defense case in chief, and I didn't care about what Alex said at all. But there was a few pointers here and there. Okay, especially during the state's case in chief in the cross-examination, when they asked for clarification about, but doesn't, I mean, her phone took 1,100 steps. His phone took 330. If he was carrying both, same make, same model, same everything, why doesn't both have 1,100 steps? Stuff like that. And then with the car data came in, that is GPS based, much more clarified, and all of a sudden, the movement of her phone, the last movement on her phone, the backlight lighting up, for whatever reason, and he's half a mile away.
Yep.
And I can't get past that. There is 999 good circumstantial evidence against him, but that one I can't get past. I simply can't. Amateur.
James just texted me. I think his ears have been tingling. Sorry, James from court. We just been talking a few days ago. Well, it's been more than that. It's been like a couple of weeks. And I think his ears were burning because everybody's talking about him now because he was there with me, or I should say I was there with him because he was there for the entire trial. I just came in a bit later. Sorry, I interrupted. You were reading something.
No.
I just wanted to let the chat know.
Yeah, we are all excited about him making sounds at all. He was gone from internet for a good number of months, so we are all happy and that he makes himself noticed, and whatever is going on in his life, take care of it. The internet will be here when he's ready for it.
Exactly.
But amateur iconoclast said Eric said he lied because he believed the local authorities were out to get him. Yeah, that wouldn't be that. Yeah. Oh, the affidavits are in my Discord. Okay. I need to read my chat more. Dun, dun, dun. Which, not in my Discord.
When I first just heard about this, I'll tell you, Nick, I think one of the viewers you have in the chat right now is the one who messaged me. It was Golden Summer. I was just furious. I was literally beside myself for a few minutes. I just couldn't even hold it in. I couldn't believe that. I mean, I am pleasantly surprised that my gut wasn't totally wrong. But think about it. Think about how much doubt, and I think you mentioned this already, how much doubt this puts on our legal system by having someone physically tamper and influence with and influence the jurors in the middle of a fucking trial.
Mm.
Let's read. I want to read this. Let's go.
Yeah, let's see how it shows first. Let's hide that. Let's make us smaller. That didn't help. How do I get rid of this side thingy? No?
You go full screen. There should be where is it? Do you not have one on the bottom right? I don't. Oh, you're using the web-based version.
Yeah.
If you download it, do you have PDF reader on your file like Adobe?
Yeah, I should have. What? Download.
If you just download it and open it in a new window,
Oh,
rather than in a tab on your browser, which I think is what you did.
yeah. Open it. Why don't I have this new computer? I have not installed a PDF reader.
Oh.
Oh well, then I'll know that until. But
this should be good enough.
Yeah. Okay. Let's see here. Thank you, Mrs. K. Griff, for sending it. Thank you so much. Dun, dun, dun. Here. Okay. September 5th to South Carolina Court of Appeals. Appeal. Yeah. Okay. Motion to suspend appeal and for leave to file motion for new trial. Appellant Richard Alexander Murdaugh, pursuant to Rule 29B of the South Carolina Rules of Criminal Procedure, hereby moves for leave to file a motion for a new trial based on after discovered evidence in the Court of General Sessions, and to suspend his appeal during the pendency of the motion. Appellant offers a copy of the motion for a new trial attached as Exhibit 1, with its own exhibits labeled Exhibit A through Exhibit L. That's a lot of exhibits.
There's 65 pages here.
Yeah. Oh. All right. Shall we do 1 page each? Save our voices?
Up to you, man. Or we can skip around. Let's see what they've got here.
That is...
Copy of... Well, we don't need to read... Unless you want to read the motion for a new trial. I'm more interested in the exhibits. It's up to you. This is your channel.
Yeah. No, I must actually... Oh, actually agree. Okay. Oh, they have... Rough draft of what?
I think it's an in-camera something it said. In-camera records.
Conference.
Exit.
Conference. This should be... the Facebook thingy. That
they questioned them under oath.
Yeah, the juror about the alleged ex-husband's Facebook post. So they have an actual rough draft case. Juror, no. Have you put anything on Facebook? Juror, not regarding the case. I put a positive post on. I gave Miss Becky my full access to my Facebook. I put positive posts on. I've done that for the past 3 years, but has anyone posted anything up on Facebook about you? And I wasn't aware of it until Miss Becky told me today about this Facebook call, supposed Facebook post from her ex-husband. She told and she asked me if I had an ex-husband, and I said yeah. And she asked me if I had talked to him about the case of being on jury duty, and I said no. And I questioned her why she was asking me that. I haven't seen my ex-husband since 2014. I mean, why was she even
involved in it?
Pulled from the jury then? if there's something her ex-husband did. Oh, and she has 3 restraining orders against him. Oh, I mean, but she told me that, Miss Becky, I assume. I was very upset after she told me that. I have, like I said, I have 3 restraining orders against him. I wouldn't have anything to do with him if I didn't have a child with him, but I haven't seen him since 2014. I've talked to him within last year because I got a call at work. Oh, that I have no interest in reading out loud. But Miss Becky said she had went look for the post again and that it had been deleted. And I don't know who she talked to or anything else, but she said apparently, when did she tell you that? It was after you let us go on that last break. I was very upset and she came down and talked to me and said that apparently, I don't know who talked to him, but said that he was drunk and he removed the post. Jesus Christ. Miss Becky, what the actual F have you done?
What surprises me the most, or maybe it shouldn't, I don't know, is not that she actually did it, but she did it and she thought she was going to get away with it without the understanding of how publicized this trial is and how many eyeballs are on it and are going to be on it. Either
Yeah.
she underestimated the publicity, which is possible. I mean, you know, you grew up in a small town, you're used to the small town shenanigans. You probably
Yeah.
do it on a regular basis, and this is just going to be business as usual. So we're going to have a couple of cameras, whatever, no big deal, kind of thing.
Yeah. And she trusted them to stonewall the defense, to never talk about it. But then she released the book and started to make money on it. Maybe she got cocky and started to tell people about her book. And the jury has ears. What? She released a book, but conspiratorically, she told me I shouldn't write about this. Because jurors might have an interest in this if they are being connected with a publicist. Because jurors writing books is far more interesting than the clerk.
Right.
And nobody else has done interviews. Nobody else has released a book.
Well, no, the jurors in the beginning, remember, or at the end of the trial, I should say,
Yeah.
they did
They
interviews,
did.
but that was It's shocking that they did not mention anything about the clerk. They were probably terrified.
Yeah, but now the defense will kick and scream until they get a hearing, and then everybody has to testify under oath. So this might just be the tip of the iceberg. Okay, so now we know that she actually... Okay. Affidavit of juror number 326. Affidavit, okay. Not
You want me to read this one?
Yeah, sure.
Personally appeared before me Holly Miller, who is being first duly sworn, deposes and states as follows. So this is a statement of a person who not only is, you know, stating this information, writing this information, however, how have you, but they are also swearing by it with a notary public that this is absolutely 100% the truth, which is very, very important and very different from just making a statement to like police or government or whatever. So this is backed by, if anything that they say in this piece of paper is false, they can be charged with perjury officially. This is one of those links, by the way, for the chat. On August the 6th, 2023, so about a month ago, Poot, Griffin, and I met with juror number 326 in the case of State of South Carolina versus Richard Alexander Murdaugh and his mother at her home located at the address. During the meeting, juror 326 relayed the following information to us. Juror 326 was asked if Ms. Hill told the jurors not to let the defense mislead them. He did not specifically recall this statement, but he did recall that Ms. Hill commented to him and other jurors about the photos that would be admitted into evidence, indicating that the images, quote, images would be disturbing. Juror 326 also stated that the jurors were stationed in two separate rooms when they were not in the courtroom, and that he was in a room with mostly other male jurors. He was not in the same room as jurors 630, 741, 785, and 785. Juror 326 stated that Ms. Hill would visit the other room more often and that he could hear what she was telling the jurors in the other room. Oh, sorry, could not hear. I apologize. Could not hear. During the trial, Juror 326 and others discussed the case prior to deliberations. He did not discuss the case with anyone outside the jurors. He further commented that some of the jurors were going into their office because of financial reasons and that, quote, people were talking to coworkers because coworkers wanted info, end quote.
Oh.
So this is beyond Becky. This means that they
Yeah.
were violating their oath that the judge instructed in the beginning, that you shall not discuss this case with anyone other than yourselves and only at the time that this case is over. So they
Yeah.
double violation. They spoke with others and they discussed the case before the case was over.
Oh.
Wow. Before deliberations began, Juror 326 indicated that minor conversation led him to know who was a yes and who was a no, end quote. His vote changed with new evidence, whatever that means, with new evidence. As the jury was deliberating, the bailiff and Ms. Hill told the jury, okay, here we go. As the jury was deliberating, so now they're in the deliberation stage, the bailiff and Ms. Hill told the jurors that they could not take a smoke break during deliberations, and knowing that there were 6 smokers on the jury. I don't know. I would kind of paint that as a threat. If I were a prosecutor, I could spin that as a threat.
Yeah.
After the trial concluded, a group chat was formed with the jurors, but Juror 326 dropped off of the group because there, quote, were too many chats, end quote. When asked if he thought the clerk of court, Becky Hill, was inserting herself into the process of the trial, Juror 326 responded, quote, I can see this, end quote. And this is one of 3, right?
Yeah, I think so. Memorandum from Rebecca Hill, May 9th.
Oh, May
Okay.
9th.
To blah, blah, blah. Dear someone. Oh, this is
The book
DreamWorks.
deal.
This is a book deal. May 9th. When was this?
The trial ended on March 1st, February 27th, something like that.
Yeah. Okay, so this is sometime after. Dear Redacted, I'm looking forward to your upcoming docuseries on the Murdaugh case, and I hope you'll be able to use some of my interview should you choose to. Because I am an elected official, we'll need to modify 3 clauses in the location agreement you presented me as it relates to my authority. Please change the word owner to Colleton County in every reference in the agreement. 3 dates and location fee. Low Country Story LLC agrees to pay Colleton County Treasury a fee of $1,000 per day for the use of the Colleton County courthouse facilities, so as long as it does supersede any court proceedings. Payment will be made by the close of production. So the docuseries needed permits and pay a fee to use the courthouse, I would assume.
Yeah.
So Miscellaneous. Colleton County, South Carolina can only enter into legal agreement for services if it is to be governed here in South Carolina, not New York. As elected official, I have no authority outside the state of South Carolina. So she inserted herself in the docuseries as well.
It's
Would assume.
interesting that she decided to change the miscellaneous. So it's like standard boilerplate language because the company is in New York. Anything that happens, we're going to litigate in New York type deal. And it's just a lack of understanding that I find funny that she's like, I just want to make sure it gets litigated in South Carolina. Not even because I only have authority in South. She doesn't understand. That's just silly.
And a note here from RHH. Also, we exchange for the use of the likeness
Rebecca Hill. That's Rebecca
of
Hill.
Rebecca Hill
RHH. Yeah.
in an interview. And I have no idea.
Wait, let me
4.05.
Let me see if
does
I
it
can.
say?
Also, in exchange for the use of the likeness of Rebecca Hill in an interview, okay, fair. Wait a second. You're right. I can't. Chad, help us out. We need chat on this. A minimum of
A minimum.
5-second video and audio clip were accompany the usage of the first reference. The book, something for the book, Behind the Door of Justice, the Murdaugh murders, will be shown, and audio will include Becky's introduction as clerk of court for Colleton County and author of the book. Son of a bitch. There was no self-promoting.
Yeah, self-promoting in the docuseries. Oh.
Wow.
She has some gall. Oh. Oh.
I can't, bro. I fucking can't.
Jesus Christ.
She is
so she
self-promoting
used her position
while she's self-promoting after deceiving the jurors, after manipulating them. She is promoting her self-promotion even further.
Yeah. Holy.
No shame whatsoever.
Served appellant, blah, blah, blah. Okay, then the exhibits, affidavits must be... draft transcripts.
Here we go. That's another one. Oh, that's a longer one. This should be good. You want to read this one?
Affidavit of Juror 785. Will you take this one?
You want me to do it? I can do it.
Yeah, sure. Yeah.
Thanks. Personally appeared before me, blank, who first being duly sworn, deposes and states as follows. I was juror 785 in the case of South Carolina versus Murdaugh in Colleton County, South Carolina. During the presentation of the defense case, after President's Day, but before Mr. Murdaugh testified. So now we have a timeline. After President's Day, but before Murdaugh testified in his own defense, Colleton County Clerk of Court Rebecca Hill told the jurors not to be, quote, fooled by, end quote, the evidence presented to the jury by Mr. Murdaugh's attorneys. In late February 2023, Ms. Hill questioned me about a Facebook post on the Walter Burrow word of mouth page. She summoned me to speak with her alone in an office in the courthouse. She told me someone emailed her about a post my ex-husband, Tim Stone, purportedly made, which purportedly stated that I made comments to him about guilt or innocence of Mr. Murdaugh. And as we saw down the road, she never did that. She hasn't spoken to him in like 9 years, almost a decade. And she has 3 restraining orders against him. She directly asked me whether I was inclined to vote guilty or not guilty. I told her I had not made up my mind and that I wanted to hear all the evidence before deciding. Ms. Hill said, the post said, I had been drinking with my ex-husband and that while drunk with him, I expressed opinions on the guilt or innocence of Mr. Murdaugh. That never happened. And I told Ms. Hill it never happened. I did not go drinking with my ex-husband. In fact, I had not seen him in approximately 10 years. I asked to see the post, but Ms. Hill would not or could not show it to me. How convenient. I have never seen it, and to my knowledge, no one has. Later that day, Ms. Hill told me SLED and their sheriff's office personnel went to my ex-husband's house, and he purportedly confirmed he made the post. Again, so convenient that everybody is like confirming. Everyone who has a hand in the cookie jar is confirming, but there's no independent evidence that they can show of it.
Jesus Christ.
She told me she would, quote, reinstate a restraining order I previously had against my ex-husband. Whatever the
She
what does that
can't
even
make
mean?
these promises.
No, she is
She
not
had
the judge.
3 previous. I mean,
So wait, so did she just admit through? I mean, obviously through the juror. Did she just admit to the fact that she is in cahoots with the judge? Like whatever I tell the judge, he's going to do, basically.
yeah, and these now we are getting into threat and promises and force.
Using what is it called? I forget the actual criminal action. It's the using of your official duties, or excuse me, your official status to curry favors. I mean, it's political abuse of power. There we go, abuse of
Yeah.
power. I did not know about the quote unquote apology post referencing Satan until Ms. Hill's book was published.
I guess that is her ex-husband. That's an interesting wording.
Maybe I'm lost.
Mm.
I have since reviewed that post and can definitely state the post is not by my ex-husband. He does not go by Timothy. The profile picture is not him, and the phrasing of the post is not phrasing he would use. It appears to be a post by another person who happens to have the same name. It does not appear to be a post to the Walterboro Word of Mouth Facebook page. So it was all a fabrication by Becky Hill, it looks like.
Yeah.
When Ms. Hill first asked me about the Facebook posting purportedly made by my ex-husband, I showed her a picture of my ex-husband. For that reason, I now believe she always knew the apology post referencing Satan was not posted by my ex-husband. On March 2nd, the day of the verdict, I received a call from my ex-husband, Tim Stone, as I was getting on the bus to travel with the rest of the jurors to the courthouse. I did not answer. The phone call upset me greatly, and I asked to speak with the clerk of court, which I did by telephone using bailiff Mr. Bill's phone. I told her I was scared. She said, the Murdaughs probably got to him. Oh my God.
Now this is threat. This goes into the threat part. Because she is actively lying to her about a possible threat from her ex-husband, which she previously said she can reinstate a restriction order.
Yep.
Yeah.
Ms. Hill then again asked me questions about my opinion regarding Mr. Murdaugh's guilt. She asked if I was leaning one way or the other. I told her that Cretan Water's closing was good, but I still had questions. If that's not an admission of reasonable doubt, I don't know what is.
Yeah.
She asked me what kind of questions, and I replied, questions about the guns. She asked me what would make me think he is innocent. I stated, no murder weapon was found. Then she asked, well, what makes you think he's guilty? I said, Paul's video at the dog kennels. She then stated everything Mr. Murdaugh has said has been lies, and I should, quote, forget about the guns. They will never be seen again. What?
She instructed a juror to forget about evidence that might persuade her to a not guilty verdict.
And that is a direct violation of the juror's oath by talking to Ms. Hill in the first place and not reporting it to the court. It is a violation of Becky Hill's position. It is a violation of Becky Hill's oath. I mean, there's like violations stacked on violations here at this point.
Yeah.
This is jury tampering. Yes, vodka blood.
Yeah, yeah. Uh, far and beyond.
Way beyond it. With someone with a position of power, no less. You know, if this was like someone being paid outside
Yeah,
of the
or another
court,
juror say, forget about the guns, they will never be seen again. Yeah, but that's in deliberations. That's
sure,
perfectly allowed, I think.
as long as
Uh,
they weren't talking to the coworkers parallel to
yeah,
that. You know what I mean?
yeah, yeah.
But yeah, in vacuum, I guess you could. But why would someone even say that? You know, it
Yeah.
wouldn't make any sense. But you're right. Ms. Hill then asked about the views of the rest of the jury. So now she's asking this juror 736, I think it is, about, well, what are the other jurors saying and thinking? Like, do I need to basically talk to anybody else? She's thinking, right, Ms. Hill, at this point. She told me if the foreperson would, quote, just go in and ask for a raise of hands, this would be over and done with, end quote. She said, quote, everyone needs to be on the same page. Wow. Wow. She then again asked, oh, sorry. She then again said she would reinstate the restraining order I previously had against my ex husband and that she would call Judge Newman about the restraining order. There it is.
Yeah. This is her giving her promises, more or less. If you don't vote guilty, if you vote guilty, I will make it sure your ex-husband is out of your life. This is mafia type. Give us money and we will not burn down your store. This is Jesus freaking Christ.
I am going to personally make sure that the judge is influenced by what I have to say if you do what I tell you.
Yeah.
That's what she's saying.
Yeah. And now we are getting outside of jury tampering. This is getting close to coercion, which might be in another statute.
The threat and what was the other word? I forgot. It was threat and force. So this is depending on the definition, I suppose, but if you don't do, well, she hasn't said something like, if you don't do what I tell you, then I will make sure the restraining order is lifted. You know, that would be a threat. That would be a clear threat.
Yeah, but she falsely said that who made him call her? That is
Murdaugh.
something interesting.
Right.
Yeah, according to her, according to Becky. So there's, you have the
if you can link, you're on the money. If you can link Becky to the ex-husband phone call and like, let's say she called the ex-husband, hey, can you call your ex-wife? That would be a threat, 100%.
Yeah.
If you can get an affidavit from the ex-husband saying Becky Hill contacted me and asked me to call my ex-wife.
Yeah, because it's really convenient that he calls her that day.
Verdict day.
They haven't had real contact besides the kid in a decade. Why would he call her on the day they started deliberating or something? It's too convenient. And I would suppose there's too much in there for it being a coincidence.
Yeah. I then went to the jury room, she goes on. Approximately 10 minutes later, I was excused from the jury. During the proceedings, I asked Judge Newman if he had spoken with the clerk of court. He only said this is not because of your ex-husband. 2 weeks later, I did answer a call from my ex-husband. I angrily confronted him about the post he purportedly made because I knew I had not made the comments he claimed I made. He emphatically denied ever making any such Facebook post and genuinely seemed not to know what I was talking about. On one day during my jury service, approximately 1 or 2 weeks before the verdict, juror 864 and 826 were in the single toilet unisex bathroom together for an extended period. They were known to do so frequently to discuss the case. Jurors 729 referred to it as A&D time.
Discussing or yeah.
I don't know anything about that.
Let's go by the affidavit on that and not speculate.
In the van going to the courthouse, juror 864 said Special Agent David Owen lied on the stand, but that nothing would happen to him.
Yeah, that's the special agent. I believe that's the one who lied to the grand jury and then tried to lie on the stand about what he told the grand jury. But during cross-examination, he lied to the grand jury. And he tried to lie to this jury. And nothing has ever happened to that guy. I believe they said in the press conference, this year he was appointed Agent of the Year or something.
Of course he was. It's
Yeah.
also known as Liar of the Year.
Oh, Jesus Christ.
When we visited the Moselle crime scene, Ms. Hill and juror 826 walked off together, avoiding other jurors in order to have a private conversation. Oh, so when they went to the scene, Ms.
Yeah.
Hill and 826 walk off and have a private conversation.
The judge's orders was that everybody walks in a group, everybody stays silent. You're just there to watch or
Wait
to
a
look.
minute. Wait a minute. This goes beyond Becky and the jurors. If that
Yeah.
happened, the Judge Newman was there. So does this implicate Judge Newman? This implicates the bailiffs? They're all in
Yeah.
on this. There's no way you just don't notice one of the jurors walking off with Becky Hill to avoid
Yeah.
other jurors to have a private conversation. It doesn't matter if they're talking about fucking butterflies. You're not supposed to do that.
Yeah. And the judge's orders was stay together, walk together, don't talk. The moment they get there, one goes off, and there are bailiffs there. Was the judge with them?
Yes, Judge Newman went with them.
Jesus Christ.
I don't know. I don't have the facts. I wasn't there, obviously. There were cameras. Weren't they cameras? Like off to the side?
Yeah, but they weren't allowed in, so only from afar they could. I think. I didn't watch that, so I don't really know. I have to go back to the trial stream and see where they actually... Oh, I hope they have it on camera.
That would be some, but wouldn't we notice it? I mean, come on. We weren't the only ones there. I'm sure somebody would have noticed it by now, right?
Yeah. At
If it was
least
on camera.
everybody will go looking at that to see, okay. And if there are more than one
how many people
camera-
do we how many people do we have here? Chat, you know what to do. We have like 200 people here. Go,
Yeah, 160,
go find the
200 people.
footage.
Go find the footage. And also, if there was more than one camera and they switch back and forth, Law and Crime or Court TV or whoever, they are now studying what can we see.
Yep. They just filmed the cars. They couldn't film the jury. Yeah, I knew something was fishy. I was like, there's no way. I couldn't remember. It's been, in my defense, it's been like 7 months, 8 months.
But we know about Law and Crime when they say they don't film, that they don't show it. But they might have had a camera on it because they have been, in the Rittenhouse, they are on the verge of being thrown out from streaming the trial because they keep panning over to him when the judge exclusive said, don't focus on the defendant, focus on what's said here. And they still pan back. So they are in a bit of a trouble there. So there might be footage, we just don't know about it. And looking at how the jury seem to wander off, who's to tell if one of them filmed it? Yeah, you never know, but that's speculation. But walking up,
The juror goes on. I own a rental property, which is leased to two tenants, Deborah Webb and Clifford Dandridge. On Saturday, February 18th, 2023, I delivered a refrigerator to the property. I was removed from the jury on the day of the verdict because a co-worker of Ms. Webb reportedly said I expressed an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator. Ms. Webb then worked at Domino's Pizza in Walterboro, so the co-worker would be some employee of Domino's Pizza in Walterboro. I do not know whether Ms. Webb actually made any such statement at Domino's Pizza or whether a co-worker actually heard any such statement. After I was dismissed from the jury, I spoke with Ms. Webb and Mr. Dandridge, who both vehemently stated to me and my husband that the affidavits the prosecution drafted for their signature was not what they said to him. They told me Sledge showed up at their home at 10 p.m. after they were asleep, removed them from the home, put them in separate cars, and questioned them. Mr. Dandridge said he told them I did not say anything about Mr. Murdaugh's guilt or innocence. They returned 30 minutes later again, woke them from their beds a second time, served them subpoenas, and told them to appear in court the next day.
Jesus Christ. It's all of them.
Yep.
All of them. Oh, this is now we are entering into the realm of conspiracy. Jesus.
I don't want to talk about it. This is too much, man. It started with Becky, and I was like, all right, she's the bad actress. Fine. She had a motive. I mean, Sled also has a motive. They want a conviction, obviously. They want a pat on the back.
Yeah. And it seems all of this because she told Becky she wasn't sure. And boom, gone. On the day of the verdict.
They arrived at the courthouse at 9 a.m. the next day. They were held for 9 hours until 6 p.m. when SLED officers and prosecutors finally presented typed affidavits to them saying they were their statements from the previous night that had been recorded by dash cams in the patrol cars. They said they just signed the affidavits without reading them.
Everybody, say it with one voice. I get a lawyer. It doesn't matter if you're a witness, if you're accused, or anything. Get a lawyer.
What he said.
Yeah. There are two questions you ask. Am I under arrest? If they say no, try to leave. If they hold you, you are under arrest. You lawyer up. And the next statement is, I want a lawyer. This is not even legal advice. This is general advice for every single one of you. Lawyer up. Otherwise, this crap. See, this crap happens. Lawyer. And these are innocent bystanders who are treated this way.
Who trusted the government. Remember, right? That's what she just, or I say she, could be a he. I think it's a he by admission because he was not with the females or whatever, the male jurors. Sounds like it was probably a he. Or no, I don't know. I'm getting lost. This is just so much, Nicholas. I'm sorry. I'm like... Yeah. Anyway, the point I'm trying to make here is this person who allegedly didn't even actually happen, spoke to Domino's employee, whatever, the refrigerator delivery, whatever. Now they get hooks sunk into them. They are basically psychologically tortured for a day. They're given pieces of paper, said, this is what you said, sign it. They were like, okay, this is what I said, signed it. And it's not even what they said. I'm with you, Flux. I'm not going to read your statement, but I agree with you 100%.
Yeah. And this also tells how little confidence they had in their case.
No, it's not even
The-
that. It's I don't I no oh no I disagree, Nicholas. I think they
Okay.
just wanted to make sure they get the result they wanted at all costs.
Yeah.
They didn't care what they believed and what they could prove. It's what they're going to get, and that's a guilty verdict.
Yeah. And whoever this affidavit signer is, I hope she has home protection.
Yeah.
Because if law enforcement and county clerk, yeah, but yeah, Jesus Christ.
Can you do me a favor? Highlight Chandler's comment. This is going to be the next stage, by the way.
Kind of frustrating. I really want to understand the process whereby they engage a motion to vacate the verdict. According to Tragos, they want an evidentiary hearing to discuss the affidavit.
And I wonder who's they? Are the government? I imagine, not the defense. I mean, the
No,
defense wants it by default, but I wonder if
The
the government
process
is going to be like, we want to cross-examine these jurors because they probably want. They want to make sure
Yeah.
that this is legit because they're terrified right now that they're being
Yeah.
outed. And here's the other problem. Let's say SLED did all these things. What if some of the individuals involved in the tainting of the jurors and the tainting of the process and the falsifying of documents are also going to be the same people that are supposed to testify the second time in the next trial? I mean,
Yeah.
now this is evidence that can be brought to impeach them.
Yeah, because Jesus Christ. I mean, if they are prepared to go to this length to vacate a person who simply doesn't want to say guilty or not guilty to the county clerk, what else are they prepared to say on the stand under oath? We now know Miss Becky has her oath, the oath she took means nothing to her. The oath the cops take when they, I assume they take some kind of promise to the flag and the Bible. That means nothing to them. The oath they took when they took the stand means nothing to them.
The juror goes on, as I as I previously testified, I never discussed the merits of the Murdaugh case with Ms. Webb, Mr. Dandridge, or any other person present, nor did I express an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator or during any other interaction with them during the trial.
August 13. Sworn.
3 weeks ago.
Yeah. They have, and this is just a couple of weeks after her book came out.
Yep.
So they started talking quite fast. Let's see, that was jury number 785. Here is P. Barber. I don't know who that is. State of Carolina, County of Richland. Affidavit of Philip Barber. Personally appeared before me, Tim Stone, who being first duly sworn, deposes and states as follows. I am an attorney in the firm of Richard A. Harpootlian, PA, and counsel of record for defendant Richard Alexander Murdaugh. On August 18th, 2023, I met with Tim Stone at his home. He provided his Facebook login information and allowed me to download a copy of all his Facebook activity from January 23rd, 2023 and March 2nd, 2023. A true copy of the download is attached as Exhibit A. The content of the download speaks for themselves, but review of them shows no post was made from January 23rd to March 2nd. That must be. No post was made on February 16th, 2023, apologizing for a previous post. There are no posts whatsoever to the Facebook group Walterboro Word of Mouth. Facebook's stated retention policy for deleted posts is 30 days. So any post deleted in the period January 23rd to March 2nd, 2023 would not be recoverable. But you have, what's that?
Metadata?
Yeah, that should still be saved, but they have to have a court order to provide it. So it should still be recoverable in some shape or form. And this was September 4th, 2023. Jesus Christ. So this is just affirming what she said. Okay, what's this? Okay, this is Tim Stone affidavit. Personally appeared before me, Tim Stone, who being first duly sworn, deposes and states as follows. I am the ex-husband of blank. I did not post anything to the Facebook group Waterboro Word of Mouth between January 23rd, 2023 and March 2nd, 2023. I did not post anything on this social media page or my own Facebook social media page about blank being a juror, that blank was talking way too much to friends and family about the case, or that Satan had gotten a hold of me and I'd been drinking at the time I posted and was now very sorry. Nor did I post what is attached as Exhibit A, which has been presented to me to be an alleged post to the Waterboro Word of Mouth Facebook page and a court exhibit in the state of South Carolina versus Richard Alexander Murdaugh-trial. I do not have a Facebook page set up as Timothy Stone. My profile name is Tim Stone, and my Facebook page is redacted. I was never contacted by law enforcement, the South Carolina Attorney General's office, the clerk of court Becky Hill. Okay, now we know that he was never contacted, so perhaps it was purely coincident that he called her on that day. Or anyone at the Carterton County Clerk of Court's office about Exhibit A, or a post on the Waterboro Word of Mouth Facebook page concerning my ex-wife. I did not know blank was on the Murdaugh jury until I heard her voice on a recording when she was being excused as a juror and she was discussing something about eggs. Tim Stone, signed Timothy Stone. Okay, here's the actual post, which is apparently not him. Folks, I posted an ugly post yesterday to which I have deleted, and I kinda, in a roundabout way, directed it towards a certain person, and I would like to apologize to everyone who read it that ugly for me to do that. And yes, I let Satan control me, and I broke down and started drinking, and when I was drunk, I made that post, and I'm sorry. So this is completely manufactured.
Yep.
Does he say anything else?
What's up, Bronca?
Yeah.
We got Bronca in the house.
Hey, Bronca! Knock, knock, knock. Ooh, I'm sending him an invite as well.
Free book.
Yep.
Man, this is absolutely crazy. Like,
and I sent Chandler a link as well. So yeah, this is Satan he's referring to alcohol, I guess. So that's Satan.
That was the whole Satan conversation, because I did not think she was referring to her ex-husband like that. I just couldn't figure out what it was referring to. Yeah, but it was this post about Satan got to me and I've been drinking or whatever.
And Karen Smith and hi Andrew, have you heard of anything like this clusterfuck?
It's pretty awful.
Yeah.
Let me fix my sound here. Sorry about that. I'm at home, obviously. Hey, Larry, how you doing, man?
Good, man. I'm in my travel setup, so I know how you feel.
Are you in Poland?
Yeah, I'm in Warsaw.
How is it?
Amazing, gorgeous, cool. Fall started here September 1st.
I was there last month on a motorcycle tour, and it was fantastic.
Good for you, man. I'm glad I followed your advice.
Yeah.
Oh, did you take my advice? That's great. Nobody ever does.
No, I was like, man, look, the choices were Italy or anywhere else. And I figured anywhere else is better because now I get to check more countries off the list. So I can always come back to Italy.
Italy's beautiful, but if you're interested in meeting ladies, then I would suggest Eastern Europe. So this is obviously a nightmare, a horror story of injustice. I mean, it was always an unjust verdict. There was always reasonable doubt in this case. And all the nonsense rulings from that Judge Newman, allowing days, weeks of really irrelevant evidence into the case on the slimmest string of connection drawn by the prosecution. It was all ridiculous. All the witness after witness after witness about this theft of money. And of course, Alec Murdaugh is a shitbag. He stole from everybody. He should spend the rest of his life in prison. But that's not the legal question in this trial. The legal question is, did he murder his wife and his son? Every witness, every state witness said he loved his wife and his son. The notion that he would have killed them the prosecution's argument was to get what, a 2-week delay in his financial crimes being found out. It's nonsensical. And now the clerk just explicitly tampering with the jury is absolutely inexcusable.
Yeah, and we just read about SLED picking up potent people, holding them for 9 hours and ask them, sign this. This is what you told us yesterday. And now they claim what we signed was not what we told them.
Because they didn't read it. They just trusted the government. Mistake number one.
Yeah. And by the way, this whole thing with the smokers, I don't know if any of you have ever smoked. I haven't smoked in a long time, but I smoked for 25 years. And I can tell you, if you're a nicotine addict and you can't get your nicotine fix, you are not a rational human being.
Yeah. And I have these nicotine pouches, which I'm extremely happy about. Don't start with them because they are addictive too. But I don't have to go out and I don't blow smoke and hurt other people. So for me, this works. Chandler,
hey, Chandler.
you had a question, and I think we misinterpreted it. So ask away.
Okay, so I wanted to understand, in a situation like this, let's say that we have substantial evidence that there was jury tampering, would we go to an appeal, or would we do a motion to vacate the verdict? When can you do a motion to vacate a verdict?
Any moment.
And I just want you to understand, if I just very kindly and very sincerely, I asked this question like 20 minutes ago, and I really wanted an answer. So I don't.
Yeah, that's what they're doing now. So they've actually halted the appeal.
Okay.
While they're trying to vacate the sentence.
I see. So and they've done a motion. Or...
Yeah, they have asked the appellate court to stay the appeal in wait of this to be investigated. And they asked the Attorney General to step in because they, for some odd reason, doesn't trust the SLED to conduct this investigation, oddly enough.
Or the AG. Didn't the AG testify for the state in the trial? Do I recall that correctly?
No, the district...
I think he sat in the audience.
Yeah, he sat, he sat in the audience.
Yeah.
So can you do a motion to vacate a verdict here? And what makes the difference?
What makes the difference between what?
Well, that an appeal?
No, in terms of in what circumstance do you do a motion to vacate a verdict, and what qualifies a case?
Well, the legal standard here is supposed to be did the, in this case, the clerk, the elected clerk, did she speak to the jury outside of the environment of the courtroom about material facts in the case, not about lunch, not about can you have a smoke break? The clerk talks to the jury all day long about that kind of nonsense. But did the clerk talk to the jury about material facts in the case? And if she did, it's presumed as a matter of law that it was prejudicial to the defendant, and you must have a new trial.
Okay. And so then what would the legal process be? Do you do a motion to vacate the verdict? Do you do something else? How does it go?
It gets very specific by jurisdiction at that level, but something along those lines is what would happen.
Okay.
During the press conference, they are calling for a hearing where the jurors will testify under oath what happened. Now, they have a few sworn affidavits, which speaks volumes because those are sworn. So I can't see how they can avoid a hearing.
They
But
can.
Well, so that was what
And,
I had heard from when I went over to Tragos to ask him the same question. He said that you would do a motion, for an evidentiary hearing. You do an evidentiary hearing to discuss the affidavit. Is that accurate?
Sounds right. I mean, that's where you start. You're basically here, if you want to look at it from like a human perspective, a defense attorney is going to file a piece of paper known as a motion with the judge saying, Judge, we have newly acquired information. We have new evidence that is suggesting that there has been some sort of tampering with the jury during the trial that has influenced their decision making and the rendering of the verdict. We are asking for the court to hold a hearing where we are going to subpoena certain individuals, namely jurors, former jurors on this case, who will take the stand and will testify as to what they heard and what they've seen and what they've done in exchange for what they've seen and heard. And the judge will then issue an order that will put these people in the witness stand. They will take an oath and they will testify, and their mettle will be tested now, because now their testimony is going to be compared with the affidavits that they have filed.
And they're subject to cross the uncooperative jurors. I mean, so it's kind of a two-step process, right? You ask for the hearing. If the court grants the hearing, now you have the subpoena power of the court. So you can compel people to come in. They have to take the oath. They have to testify under oath. There's no self-incrimination thing here. The jurors are not alleged to have done anything wrong. So they'll have to answer these questions. And if they're uncooperative, they'll be treated as hostile witnesses.
Okay. And so they would be, I'm guessing, subpoenaing all of the relevant jurors who were mentioned in the affidavit or who were part of the affidavit. And then the judge would be evaluating based on that?
Well, it's not just the judge. It's basically, I mean, the judge is going to be the final decision maker, no question about it. But
for the hearing, but the evidence that's developed in the hearing will be useful for other purposes, for other appeals purposes.
Okay, that's a good point. I'm just trying to understand, how this would work, because I
want the clerk
don't fully understand the process. So
yeah,
I was curious.
definitely
put in the witness stand, and I want her to plead the fifth, which of course is what she's going to do, because she does have a self-incrimination problem. She's almost certainly looking at multiple felony charges here.
Right.
But I want her on the witness stand under oath pleading the fifth.
Yep.
Yeah, and I think law and crime, the law and crime lawyers and commentators, all in agreement. She needs to plead the fifth. She can't get her, because they have also read what we have read now, and there's a lot more. And
I mean, what would suck is sometimes what judges will do is if they know a witness is going to plead the fifth, they won't compel the witness to take the stand, because it becomes a little bit of theater, right? You're not going to get any useful testimony from them. But there's no jury here, and I'd want it in the record. So if I'm the defense attorneys, I'm certainly going to ask for the subpoena of the clerk to get her seated so she can say under oath that she's pleading the Fifth Amendment.
Yep. Yeah, that's going to send shockwaves, and it's going to speak volumes, because the fact that she does that means she has something to say and she can't say.
There are no circumstances under which the clerk should be pleading the fifth. I'm sorry. None that are consistent with due process of law for a criminal defendant.
Agreed.
You mean no circumstances under which she shouldn't be pleading the fifth? She should always be pleading the fifth, I think is what you're trying to say.
No, I think she should not be. She should be so clean. Her conduct should be so clean that she doesn't have any self-incrimination to worry about.
She has nothing to hide. She just, I'll answer any question you have.
But in reality, of course, she does have self-incriminating issues. So she is compelled to plead the fifth. I just want to hear her say it from the witness stand.
Yeah.
I see what you mean. Okay, that makes sense. Thank you, guys. I appreciate the explanation.
Yeah, and that all of a sudden that brings in everything else. Her phone records. They can subpoena more or less everything around her. Who did she actually talk to and when during the trial? And all
her computer?
Her computer.
For all that Facebook nonsense?
Yeah.
Once you have that subpoena power, you can grab anything.
Yep.
And we read from the South Carolina jury tampering, but I believe this goes far beyond jury tampering, because now all of a sudden they have these two people who she delivered a refrigerator to, who were coerced into signing something they never said by SLED, according to the affidavit.
Well, I saw Lefty Lulz's chat earlier, which I appreciated, which was, do you guys really think these are the only corrupt people in the county, that it's SLED, or that it's just, I mean, obviously not. I mean, Larry, you were there, I'm sure you interacted with a lot of the people, when you were at the trial. Does any of this surprise you that this is going on? I mean, on its face, I know that it's not, we haven't like confirmed and solidified, but there's clearly, there's documentation, there are, statements. What do you think?
Look, hindsight is always going to be 2020. Okay. I already alluded to the fact that when we were watching the verdict, I had Danny and Direct and myself watching the verdict together. And when it finally came down and it was all guilty, first of all, we were very shocked as to how quickly they came to the decision. And secondly, we were very, very surprised by the verdict, which to me, again, I'm not the kind of person who's going to start screaming, conspiracy and tampering and all of that without any evidence. I can't say that the thought hasn't crossed my mind, but I didn't say anything about it because I was not in a position to. But now, again, kind of looking back 6 months ago, what I was feeling, what Danny was feeling, what we discussed on my YouTube channel, what we discussed off the YouTube channel, it just all kind of makes sense. I mean, but I mean, I'm James. I was texting with James from court just a minute ago, and his first response when I told him about, Becky Hill is going to be implicated potentially in all of this, he's like, "Oh, no way! Like, there's no way. She is like the sweetest person." And I'm like, I want to agree with you because I was there. I met her. She's like the coolest, sweetest person ever. And then there's this dark side to her, which gives you the idea that you can't trust anybody.
But she doesn't think she did anything immoral. You have to understand, if she emotionally convinced herself that this guy was guilty, then she's just doing justice.
At all costs? Yeah. Like she feels morally clean.
Certainly why not? The prosecution was doing that. SLED was doing that. He testified on the stand that he perjured himself before the grand jury.
Well, part of the same pot type argument. Yeah, maybe.
I think they convinced themselves emotionally, because Alec Murdaugh is such a shitbag, that he just deserves whatever he's got coming to him. And of course he would have killed his wife and kid. Look what a terrible human being he is. And therefore everything that convicts him is worth doing.
Yeah.
And now she's going to get to write a book. She's going to get paid for the book. Maybe she'll be famous.
The book came out in July. Her book, and according to the defense press conference, they were being stonewalled by every juror up until the book came out and she started doing interviews and stuff. All of a sudden, they got return calls. And this has developed into a this has never been more true than in this trial. And now it's all coming out. And I can't see how even Judge Newman or whatever judge that has to who will have this motion in front of him or her, how can you sweep this under a rug? There's not a rug big enough in the world.
It was funny how careful defense counsel was to assure everybody that they weren't alleging any misconduct by Judge Newman, even though I thought he made terrible rulings throughout that trial. But of course, those rulings are within his discretion, so there's no point complaining about them.
I'm not sure if I would call him biased. I'm curious what you all think, because there was somebody who mentioned that they thought that based on the decisions that he had previously made, that essentially they could see him allowing anything. Do you think that Judge Newman is biased, or how do you see him responding to this?
We have this incident with the jury walk around on the premises, where this one affidavit claims that one juror walked off with Miss Becky. And
to have a private conversation.
Walked off from the rest of them. And Judge Newman was there during the walk around.
But it depends on what they were talking about is the issue. So the clerk talks to the jurors all the time. You know, what would you guys like for lunch? You want to go back to that chicken place, or you want a hamburger, or what? You know, so it depends on whether they're discussing a material element of the case.
You,
If
you
they
do
are,
bring a
then it's
good
new
point,
trial.
actually.
Yeah.
You do bring up a good point, Bronco. I didn't think about that because I thought any type of impropriety would immediately be honed in on by somebody, you know. But because of her position of authority and her position as a clerk, you're right. It may not immediately arise suspicions. I actually take my words back.
If they want to take a cigarette break, they ask the clerk, you know, or they ask the bailiff.
Yeah,
ask the clerk.
but that's like, you know, like a 5-second question. It's not a walking away into the distance with outside of earshot. That's where the suspicions kind of.
Some of those Southern gals like to talk. You know, they're talking about lunch. They maybe, you know, spend 5 minutes talking about the different restaurants they've gotten food from so far and who liked what and who didn't like what.
In itself, it's not suspicious, but with everything else.
Well, now I want to know. Now I want to know
exactly.
what the F that conversation was about, right? Because we have reason to believe they were having conversations about material things. This is not the normal course of conduct for court. We can't just assume that it was about lunch or cigarette breaks or anything like that because of the sworn affidavits we have.
Yeah. And the order from the court was that everybody walk, nobody talks. And all of a sudden, they are split into 2 groups because everybody didn't fit into the rooms, and then one walks off. And all of a sudden, don't they have to ask for permission? And is the clerk the person to... Yeah, it probably is the person to ask for permission. Yeah, I'm just speculating here. But in itself, not suspicious. With everything else, Jesus Christ.
And of course, you need to be able to approach this from a rational perspective, right? Nothing's getting Alex Murdaugh out of jail. I mean, I believe he pled guilty in federal court to all the financial crimes. So I'm sure that's 100 years in prison.
Right.
But people need to keep in mind, as much of a shitbag as he is, as much as he deserves to be in prison for the rest of his life, that's not the legal question in this case. The legal question is, did he murder his wife and his son? The evidence was ambiguous at best, contrary at worst. And that's reasonable doubt every day of the week and twice on Sunday.
Absolutely. If I was on the jury, I would have voted not guilty. I didn't see it. I saw potential, but it wasn't strong enough to convict him. And that's the funny thing is that I wasn't as surprised when the verdict came down as I thought I would be. But I was really disappointed because I felt very strongly that the verdict came from a place of very strong bias. When you look at the culture of South Carolina, I mean, there were so many people who made a lot of money off of this trial, and off of, you know, calling him guilty and using a lot of very irrelevant things that were not even in evidence to convict him in the court of public opinion. And so I think that there was no way he was ever going to get a fair trial in this case, and I don't think that we will ever have a true answer as to who killed Paul and Maggie. But when this was the case that brought me in to YouTube, and I didn't think he was guilty, and I still don't.
Now, here, one of the things that is interesting that is in the affidavit is this is an excerpt from her book.
Oh.
Let's see if I can... Let's see if there is more. Oh, there's more!
Oh, man.
Yeah, this is her book, Behind the Doors of Justice, The Murdaugh Murders.
Should be retitled Behind the Doors of Deceit.
Yeah.
I like that better. That's really good. You were quick with that, huh? I like that.
I heard Larry mention earlier, I was actually running errands on my motorcycle, but I was streaming all of this on the bike, and I heard Larry mention earlier, this is having the clerk write a book like this is as ridiculous as having the stenographer do it. I mean, who cares? They're not counsel. They're not making decisions. They're just half-ass observers in the courtroom.
Yeah. A juror writing a book, interesting. The clerk,
and frankly, it's just inappropriate.
Yeah.
Well, it's incredibly inappropriate, but everybody wants a piece of the pie, right? So it's not exactly
And
a
she
surprise.
wanted it so badly that she manipulated the justice system to get what she wanted.
Yeah. And
oh man, if it comes to her being charged and convicted that this was for profit, is going to be horribly destructive to her. If I were sentencing.
Yeah.
Definitely. Financial interest,
And,
personal vetted interest.
Yeah. And according to the juror's affidavit, with SLED agents waking people up in the middle of the night just to get testimony to remove a possibly not guilty vote. I mean, they took steps to ensure a guilty verdict just because she or he did not want to tell the county clerk where she was leaning.
Just take Alec Murdaugh out of it. If any of us had a loved one or ourselves who was being criminally charged, we wouldn't want this kind of conduct involved in their prosecution. SLED waking people up in the middle of the night, perjuring themselves to a grand jury, fabricating evidence, getting statements from people after 9 hours of isolation that they say they never actually said. The clerk writing a book about it. I mean, none of that would feel like justice to us.
Well, no, and of course it's not justice, because if you truly believe that this man is guilty, you want everybody's hands to be clean when he's convicted. You want that conclusion to become to, based on all of the evidence in front of you, completely clean, no corruption, whatever, period. And I don't see lack of corruption here. I see least option.
Yeah.
And for the chat, I just removed the troll from the chat. So, yeah.
And as Nicholas said earlier, the whole point here is that if we don't provide due process of law for the worst of us, you can't expect it for the best of us. I mean, then it exists for nobody. Then it's the machine, it's the matrix determining whether or not we get anything that resembles justice or not. And that's not the way it's supposed to work.
And everybody will lose faith in the system immediately. I mean, everybody already distrusts it, but if nothing is done, the whole system collapses under its own weight.
Yeah, and what this case, with this, how will that affect everything? Every suspicious guilty verdict in South Carolina under Judge Newman and his county clerk? It has to be investigated.
This will have ripple effects, not just on their cases in South Carolina. Sorry, my video keeps glitching. I don't know why. I'm just going to turn it off. This is going to have ripple effects, not just on South Carolina, but it's going to have ripple effects on the entirety of the United States of America. That's the problem.
Yeah. Imagine if some young black man had been charged with these murders on this evidence and been convicted, and then this stuff was disclosed. How would the public view that?
Cities would have been burnt down. If something like
that's pretty much it.
Yeah,
you got it, Nicholas. There, somebody would have run over with their car. There would have been mobs and terrible.
Yeah, and but now it's the worst of them. So now, but we already have one of these earth-shattering that. That Jeff was surprised about. One of the medical examiners in the O.J. Simpson trial has now been confronted with evidence tampering. What was his name? He's one of the guards in medical examination, and has been doing it
one of the medical examiners. I'm not sure.
He was in the O.J. trial on O.J.'s side, I think.
We watch OJ every week, but we've only gotten through 2 witnesses thanks to Fung being on the stand for like eons.
Yeah.
I mean, we literally did Dennis Fung for I think 6 months, and we did it every week. So that took a while. It was like Dennis Fung was the one who was on trial, really. But I did actually kind of want to go back to one of the. Can I go back to one of the points that Branka just made? I just wanted to comment on that real quick. Because here's the thing. I'm going to say something that's maybe controversial and that nobody really wants to hear. The guy got convicted because he's a rich white guy, in this county where he runs everything, his family runs everything, and everybody hates him for that. And he's going to be convicted on the basis that he has all the gold and all of the wealth and all the whatever, and everybody, all of the people who are not as successful are going to look at him and they're going to convict him on that basis. He definitely committed
Especially when
some.
people believe he didn't earn it,
Right.
right? He stole it.
Yeah.
Right, because
And he's living large on the hog, right? He's got the
because it's an
boats,
old
he's
money.
got the hunting property, he's got all this, the beach house, he's got all this stuff
Yeah.
that they don't have. And then you might
Yeah.
accept that if you believe the guy earned it. But if you believe the guy stole it from cripples, from his partners, from his family, burn him.
I mean, he did commit those financial crimes, and sure, they were terrible. And yeah, he took advantage of people who were, very much, they were not as well off as he was. And yeah, that was a terrible thing to do. Does it make him a murderer? No. Do we have proof that he murdered his family? No, we don't. Do we have a motive? Really? No. I mean, I'm sorry, we don't have a motive. We do not have a motive that I can perceive. I tried to make one up once in the very beginning, that like maybe it was like to protect Paul from, being put on trial, and that the mom couldn't live without it. It's just too complicated. I don't
They're
really
all
see
completely speculative, right?
Yeah.
There's no motive that I ever saw that would convince me beyond a reasonable doubt that he murdered his wife and son.
And a lot of people hate the family. So I'm sure there was a lot of reason to, there were probably other people who wanted to commit crimes against them, and I could see somebody else doing it.
Yeah, this is the guy, forensic scientist Henry Lee, and he has been a professor for many years. He's teaching his methods.
Wait a minute. I think I heard him speak. He came to a conference I was at. He did a lot of very famous trials, including, remember the one who alleged that his wife was killed by an owl attack and she fell down the stairs?
Yeah.
That was him.
Oh,
he was the guy.
that case.
Yeah, he
That's
did
not
a
a
lot
very
of
wise
famous
argument.
cases. Well, he tried. Yeah, he's very famous. Like, he actually rose to, he's like the creme de la creme, I believe, unless I'm mistaking him for somebody else, but I'm pretty sure it's him.
Yeah. Let's see if they say anything about, Lee, former head of the state's forensic laboratory and now a professor emeritus at the University of New Haven's Henry C. Lee College of Criminal Justice and Forensic Science. Yeah. Lee,
Yeah, it's him.
Rocketed to fame after his testimony in the 1995 O.J. Simpson murder trial, in which he questioned the handling of blood evidence. He also served as a consultant in other high-profile investigations, including John Bennett Ramsey, Scott Peterson, and Phil Spector. Jesus Christ. I mean, yeah. So,
right, so he does the OJ trial. You think he knows when he's testifying for the defense in the OJ trial that if he testifies in a favorable way that leads to a good outcome for the defense, that he's going to get millions of more of these consulting gigs?
Yeah.
Of course he does.
Yeah.
And he did.
And this is the,
right? And
yeah,
made his
and this
career.
is
Now
the-
he doesn't actually have to do medical exam. He doesn't have to touch those yucky bodies anymore. Just a few times a year, he testifies in court, gets paid a ton of money.
Yeah.
Wait, question. Are we sure that he testified during the murder trial, or was he testifying at the civil trial that came afterwards?
No, questioning the handling of blood evidence in the 1995 O.J. Simpson murder trial. So yeah, he testified in that trial.
Oh, he did. Okay. I mean, like I said, we've watched Fung, and now we're watching Mazzola, and it's been like 6 months, 7 months. So I would be curious to see what he testifies about when we get there.
And yeah.
So anyway, back to, so you were bringing him up for the reason of, I'm trying to remember why you were bringing him up.
We already have that extremely famous person, and now everything he has ever testified to for the past 20 years is being in question. They have to reopen some cases. He's been testifying in death penalty cases. He's been testifying in really high stake trials. And now, either way, if he testified for the state or for the defense, some of them might have to reopen. And God forbid, say he testified in a death penalty case, got the guy convicted, and now he's executed. And so that's...
People are terrible. People are
terrible. Yeah.
Yep.
And
don't trust anybody, folks.
Yeah.
Good advice.
And now you have this with the county clerk, a SLED, And yeah, people didn't trust the system before this, and I don't think it will improve.
Well,
Now without an
thank God these
overhaul.
trials are televised now, and we have channels like Nicholas, who and you, Larry, of course, and you, Chandler, who are covering these trials, because we in the law see this stuff. I mean, not to this level of egregiousness typically, but we see the stuff that happens in a courtroom, but no one else does. I mean, even if those reporters there, they usually don't know what they're looking for anyway, so they don't really see what's going on. They're kind of half blind. But now people can see the kind of shenanigans, the craziness that happens in these courtrooms. People just assume that everyone there must be, other than the defendants, a professional, right? The prosecutors are legal professionals, defense lawyers are legal professional, the judge is a legal professional. Surely everything runs like a well-oiled machine. No. These can turn into circuses without any effort at all.
Yeah. And still brings me back to the Zachariah Anderson case. How anyone is beyond me. How anyone can see the evidence beyond reasonable doubt. Yeah. And now this Murdaugh guy.
I see Solomon Anderson's in the chat. Solomon, can I say a word to him on the side for a second?
Yeah, sure.
I had communicated with Solomon separately. I'm interested in covering. I didn't watch the trial, the Zachariah Anderson trial, but given what all my friends and colleagues that I respect are saying about it, it certainly seems like a miscarriage of justice. I'm interested in going back and watching the trial. The problem, Solomon, and I told Solomon I was interested in doing that. The problem is I need to find like the 2 or 3 weeks of solid time that I can actually do that, because I'm not a guy who can just watch summaries. I need to watch every minute of testimony.
Yes, yes, you
so
do.
If I can arrange that, then I'm happy to do that. If I can't, all I can do is support my colleagues who actually watch the trial in real time and affirm their perceptions of what happened.
Yeah, that's because normally if you have 10 lawyers in a room, you will have 14 opinions. I have yet to have met a lawyer or a person with a law degree who doesn't have this jaw-dropping for the conviction.
We have 4 lawyers and 5 faces.
Chandler,
See,
stop showing your pussy for the audience.
Oh,
Nick.
Nick. Nick. I'm warning you. I'm gonna leave if you.
I actually interviewed Zachariah Anderson's brother, Solomon Anderson, on my channel, and I must say that although it may not appear that I was fully invested into the trial, I've just had other things to do. He's a solid fella and was a pleasure to interview. I will say that.
I've also had Solomon on my channel, and right now we are going over the legal regulations for Wisconsin. We're going to do a stream about that soon, and it's the kind of thing you do there. It is a lot of work to go through and watch the trial from start to finish. I was able to watch it when it was happening. I went on with Legal Vices, I went on with Aussie Overlord, and I would do the morning and afternoon sessions, and you really do need to watch it from start to finish. But I'm really glad that you're interested, and I would love to hear your take. Definitely. Okay.
I'll tell you one thing. I have zero interest in visiting either Wisconsin or South Carolina. I do not want to risk getting enmeshed in either one of those criminal justice systems, because they're circuses.
I mean, I've been watching what's his face, Austin Ford, what's his name? And the amount of non-legal representation he got in his trial. And I'm thinking to myself, I could go over there, take that bar exam tomorrow, probably pass, if that lawyer, could work as a lawyer. And that is the werewolf lawyer who showed up right after he awakened under the bridge.
So if you think it's bad now, just wait a couple years, because what's happened in America is the universities figured out that law schools were profit centers, because you don't need like laboratories and stuff. You don't need a gymnasium or a stadium. You just need a bunch of empty classrooms. You bring in a bunch of lawyers, and suddenly you have a law school, and you can charge people a ton of money. But the people actually qualified to be lawyers is a relatively small fraction of the population. So it's like if you have an expansion team in baseball, right? You decide you're going to double the number of baseball teams. Well, all the new teams suck because there just aren't that many world-class players. There aren't that many people really competent to practice law. And when you vastly increase the number of law schools, you bring in these students, they borrow a ton of money, they go through the 3 years, and then when they go to take the bar exam, they can't pass the bar exam because they're not actually equipped to practice law. So what do? Guess what the answer is? You get rid of the bar exam. Yeah. So you don't require a bar exam anymore. You graduate from law school, and that's fine. You can just go out there and practice law. And if you think the trials are circuses now, wait until we have people making arguments in those courtrooms that never even had to pass the bar.
Oh, God.
Yeah. Imagine how insane it's going to be like having arguments with the drunk guy at the gas station at 2 a.m.
I've seen that trend. There are all of these, law Twitter. There are all of these people who are like, abolish the bar exam because it's sexist and racist and misogynist, and it's a boundary that keeps people from being able to, be attorneys. I don't know how you feel about that, but I just find that very funny and very interesting.
I passed 2 bars. I didn't find them very difficult, but
yeah, it shouldn't. I don't know. Maybe it's just because I'm a good test taker, but I don't see any problem. It's not like I've taken the bar yet. I haven't even taken the LSAT yet. I'm taking the LSAT in November, but I'm looking forward to it.
The bar exam, right? So well, you may not know yet, but here in the U.S., it's common for you graduate law school, you take a bar review course for, I don't know what it was, I don't remember, 8 weeks, something like that, where you go every night and you watch videos and practice tests and all this kind of stuff. And then when you go to take the bar, it's not very difficult. So, and then you forget all that stuff the next day. And in any case, you're only ever practicing law generally in 1, maybe 2 kind of finite areas. But what it does do is it tests your ability to take that exam, apply reasoning to facts presented to you in a stressful situation under pressure, and mostly get the right answers. And I would think that's the minimal you would want from an attorney who's representing you when the consequences of misrepresenting you could be financially destructive or the rest of your life in a cage.
Definitely.
Yeah, and that is how we build up here in Sweden our driver's license test, the theoretical test. You get these questions to you, not because they are being in the test, because you need to learn how the questions are asked and how the answers are presented. And once you learn that, the test is easy.
Yep. It's about how to cogently be able to apply legal principles to a question being asked. That's it.
Yeah.
You identify the issue. What is the rule that is to be applied? How does the rule apply to this question? And what is the conclusion that is logically cogent based on the data provided and the rule applied? That's it.
Yeah.
I mean, there was a time when we treated the law more like a trade, right? Where whatever legal education you might have gotten, and it might be very little, you'd go work for a lawyer and you'd be working for that lawyer for a number of years. And then you would read into the law to be admitted to the bar. I'm not saying we should go back to that system because I think it has its own problem. I was very happy to just be able to take. Yeah, it was like an apprenticeship, right?
Yeah.
I was very happy just to be able to pass the bar and start practicing law. That was great.
Yeah. Jessica makes a good point here. She passed 2 bars on the way to the 3rd and 4th. They had better drinks, and I must say, I have a hard time passing a bar. There is.
I don't know. I find it easy.
It's a bar up in Stockholm called The Gym, which is excellent because where have you been? At the gym.
Hey, are you not drinking, Larry?
Yeah, I'm about to celebrate my 57th month of sobriety.
Good for you, man.
Congratulations. Yeah.
Thanks.
I tell you, I have to say, I keep meeting more people that I respect who just don't drink alcohol. And I like to drink. But when I think about it objectively, I can't think of anything positive it's done for me. except alter my mood,
It calls for some good times sometimes. I get that. I'm an ex-drinker. I know what it's like.
Yeah, I've been practicing for a very long time, and I'm finally getting good at it.
Well, you can drink for Larry then.
Yes, you can drink for me for sure.
And I don't have a drinking problem because I'm never out of booze. And yeah.
Nice.
No, but occasionally I have these drinking streams where people pay me to have shots, and those are fun and games. But then mostly as Jeff does, then I don't drink anything for a good while. because
Because you're in a coma.
I'm in a coma. Yeah, that too. But after my last binge stream, just a few days later, I had a checkup and everything was fine. And I was as surprised as the doctor. But apparently, I can process alcohol quite well. But that might not be a positive thing in the long run. So I need to have everything in check. But at least I'm aware of it.
There's an old joke, and I'm going to modify it slightly. So Nicholas actually went to the doctor the other week, and he was shocked to find out when the doctor said that they found whiskey in. Sorry, I just ruined it. They found blood in his whiskey stream.
Yeah,
very funny.
I mean, I have this, and then I have. Yeah, everybody should have a bar globe, even if it's just for lemonade.
I mean, I just earlier this year, I was an expert witness on a murder trial where the guy who got killed was, and of course I was an expert witness for the defense, but the victim who got killed, his blood alcohol was like 0.4 something.
Wow.
Jesus
0.4.
That's really
0.4. I mean,
quite something.
oh my God. And of course he was a homeless, lifelong alcoholic, you know. But
That's
for most
why.
of us, 0.4 would probably kill us or at least put us in a coma in the hospital.
Yeah.
And the medical examiner was like, no, that's probably that guy's standard level, like every day. I mean,
Well, I imagine if he drinks less than that, he probably has extremely intense withdrawal symptoms, and you can go into that state where like you start shaking. It can be very dangerous for somebody who consistently has alcohol as part, that, like as a large
0.4, and he was still functional enough to get into a fight with the dude who killed him.
Wow.
Damn.
That's wild.
And
by the way, I got that dude acquitted.
Nice.
Shameless plug. I love it.
Yeah, shameless plug. And but we had that trial not that long ago. What was the name? David covered the trial with the guy who was covered in Lie. And he had, once he got to the hospital, he had a 0.28, and he claimed he didn't drink the entire day. And yeah, what was that trial? Chat, help me.
While you're doing that, Nicholas, I'm gonna dip out, you guys. I gotta get some work done before I go to bed here. It's already 11 in Warsaw p.m. It's been a pleasure.
Go to Krakow, Larry.
That's what
beautiful.
people keep saying. I need to check it out.
Yeah, go to Krakow. Strongly recommended.
Have an incredible time.
Thanks. I'm here until the 14th, and then the world is my oyster. I have Amsterdam, Monaco, Barcelona, and London on the list.
Beautiful.
Yeah.
Hey, can I make a recommendation? Amsterdam.
Maybe Sweden.
Have you been to Amsterdam before?
Not yet. No.
Okay, I gotta be. So I lived in the Netherlands for 2 years. I find Amsterdam kind of to be like a big dirty city, like a New York City. But there's another town in the very south of the Netherlands called Maastricht, Maastricht, I guess. That's where I lived for 2 years. It is beautiful. It looks like something from a fairy tale. It's an old fortress city. It was established by the Romans. It's absolutely gorgeous. It's like a 2-hour train ride from Amsterdam. So maybe you could go through there on the way to Amsterdam or something. But if you go to the Netherlands and you skip Maastricht, you're really doing yourself a disservice.
Gotcha. I'll make a note of that. Thank you.
Yeah. And if you ever have the opportunity to go to the south of Sweden, here I am. So
all I need is an address, Nick. You know me. You give me an address, I'll probably show up.
Well, lovely seeing you, and thanks so much for answering that, helping answer that question. I was really curious. I think you spelled out some details really well, so I appreciate that, Larry. Thank you.
Yeah,
of course.
I will send you my address, and you can, just show up. We will have a drink, or no, we won't. We will have a coffee or something.
We'll figure it out.
We will figure it out. But as everybody in my chat knows, I'm currently having downstairs renovated, so everything is a dust cloud. It is the pounding everybody hears on the daytime. That is not someone trying to escape from the cellar. It's renovations.
It's an orgy. Oh, renovations. Yes.
Yeah.
All right.
But yeah.
See you guys. Have a good time. Thanks for having me.
Thank you for
Take care,
showing
man.
up. Sharon,
Good
thank
travels.
you. Good travels.
Bye bye.
Bye. Yeah, it was Konrad Imirowicz.
Amirowitz. Yeah, I watched some
Yeah.
of that.
Yeah. And also I had doubts about that case, that trial. But eventually the judge decided 1 year time served and 5 years probation, and she needs to get to school, everything around that. Because during sentencing it was brought up what extremely horrible situation she was grew up in, with alleged essay from the brother's friend, who the brother is still friends with, which is the brother who testified against her in court, claiming, "Dad told me that Megan did it." Yeah.
I should have told Larry that. I forgot. Someone in the comment mentioned that Maastricht is a university city. That's true. It's literally a wash and hot 20-year-olds. It's like an ocean of hot 20-year-olds.
I'd go just for that reason.
The pounding Nix hears is Farrell in the attic. No, Farrell lives in David's attic, not mine.
Sorry for all the cat shenanigans. I was away for the weekend. I went to wine country, and Cairo really, really missed me, and he's very happy that I'm home. So he's if you hear
Where'd
a lot
you go,
of purring,
Napa?
No, we actually, weirdly, I didn't know this, but Temecula has some really beautiful vineyards, and it was
never
great.
Been there.
Yeah, we had a great
Napa
time.
and Sonoma, but never there.
Yeah, I've been to the Central Coast, and I was surprised. I just kind of like got invited to this. One of my friends who was in my paralegal program with me, he has all these friends, and they needed like an extra person, and so we all went. We had a great time. It was a lot of fun. The wine was fantastic. It was beautiful. So very impressive and surprising.
A friend of mine had a bender in Copenhagen and woke up in Amsterdam. That was interesting to hear. We had to not bail him out, but we had to pay for a ticket to get him home again. That was maybe 30 years ago. So, yeah, and I won't tell his name. But yeah, things happen in this region of Europe sometimes. Yeah, let's see here. I think we didn't listen to the entirety of the press conference. Me and Larry went off the rails on some part. So let's listen to final stages. They maybe have a few questions left to answer. Let's see here. Sound on. Yeah.
We will get a new trial. How long that'll take, I don't know.
Have you tried to reach Clerk Hill, ask her any questions about any of this?
We've not reached out to Clerk Hill. We had reached out to some other folks, and based on the information we received, we thought it would be pointless to reach out to her.
No, of that one.
What now? We're focused on getting him a new trial. That's what we've been working on. Anything else? No? Thank you so much. Let me read this statement to him real quick.
Okay, that was the final part of it, apparently. Okay. So we stopped 30 seconds before the press conference was over. Okay. Of course we did.
Well, I definitely missed a little bit of it, but it does sound like there were some substantial shenanigans with this clerk. It does sound like the shenanigans were possibly quite illegal.
And the legal standard is quite interesting, and I think quite appropriate. The legal standard is if the clerk discussed material facts with the jury, it's a new trial, period.
Yeah.
Yes.
You don't have to show that it probably influenced the verdict or by clear and convincing evidence influenced the jury. If she discussed material facts with the jury, it's done.
Yeah, and it's not against the jury, not against the verdict, how it can influence the defense. And clearly it did. Because
it's presumed to be prejudicial to the defense.
Yeah.
Well, there's no that it can't. It must, clearly.
And yeah, it must be presumed as MG law says. Yeah. Unless you're Alec. Yeah, that's the. But I can't see it not being granted a new trial, and I would assume they would get the fuck out of Dodge, because there's no way they can hold a new trial in that county.
It's so hard. It would have to be such a political decision, which doesn't mean it would be wrong, but in the normal course of events, the new trial would be with Judge Newman.
Yeah. In a normal course of events, but if anything in the rest of the interviews, because this is his clerk. She is the voice between him and the jury.
But she doesn't work for him. It's an
No.
independent elected position. So
Yeah.
he didn't choose her.
Yeah.
He can't fire her.
No. She is an elected official, and she took an oath. And how she treated that oath? Well, according to this, allegedly, still, she's not on trial yet. She is presumed
But yeah,
innocent.
I never trusted Judge Newman when he
No.
let all that financial information in. If there was evidence that Alec Murdaugh had stolen a library book when he was 12 years old, Newman would have allowed that in, because the prosecution would have said, well, he was just trying to cover up the theft of the library book, Your Honor. That's why he killed his wife and son.
Yeah. And every time objection, irrelevance, or something like, let's take that down the line. And down the line, never happened.
No, he was incredibly permissive to the point where it was very prejudicial, and I feel like it was highly problematic. He should have, I really feel that he should have kept all of the financial stuff completely out. It was totally irrelevant. It had nothing to do with what was going on.
Yeah.
And hadn't his son just died from a drug overdose? And now we have Alec Murdaugh, the drug addict, dealing with drug dealers dude as a defendant.
That's correct. Yes. I forgot about that. That's true. Right. Because I remember somebody made a comment to him about it. And yeah.
So, I mean, it's possible the judge is not thinking drugs killed my son and I will hold all these people accountable. But maybe he is thinking that.
It's like you said. I mean, you want to think that a judge, at the very least, who is representing the court, is going to be keeping things together. It's going to be a well-oiled machine, right? We know that we can trust this judge, that things are going to be, run in the proper and correct way. Judges are people too. Judges let their biases and their prejudices come in, and a lot of judges have committed some rather, egregious crimes against the court. I mean,
they're not superior human beings.
Right.
Right. And we're all vulnerable to our emotions and our biases. So the position of a judge should be someone where there's literally nothing you could point to that would be a bias in this particular case. And we don't have that here.
Brian De Quincy Newman, former Columbia City Councilman, dies at the age of 40 from cardiac arrest. That's the only thing that's in the wiki. Nothing about drugs. But cardiac arrest at 40, yeah, it can happen. But yeah. So
No,
that
I believe it did have something to do with drugs, though.
Yeah, that was a month and a half before this trial started. So
yeah, I mean, if someone dies of heart disease at 40, they either had really bad genetics or they were really enjoying a lot of cocaine. Something similar.
A judge's son, if it was drug related, they're not going to explicitly state that.
I mean, the drugs were a thread throughout that entire trial, right? Alec Murdaugh was stealing money to pay for his drug addiction. He owed drug dealers money. Drug dealers would have a motive to kill. That was the alternative hypothesis for the defense, right? Not that they're obligated to pull up an alternative hypothesis, but they did. For all we know, the drug dealers did this, right? Because Alec Murdaugh wasn't paying them when he was supposed to be paying them. And the judge has a son who died from drugs, I guess, was my understanding. So I don't know if that's demonstrably proven or not, but we would know for sure if the son was involved in drug taking. I mean, that would be public knowledge. I believe that's undisputed. You have an inherent conflict there.
See, and you would think that, somebody who had lost a loved one in that way, that they might be sympathetic to a defendant who had an addiction issue, but it doesn't necessarily work that way.
Well, except Alec Murdaugh is not a poor black drug user. He's a rich white guy who's financing the drug enterprise.
Right. but he had a drug problem, and so clearly there was an issue there. And no matter, how much people want to go on about the fact that he didn't earn his money and, he was a terrible person, sure, okay, but be human and have a little bit of sympathy. It's, he was an addict, and obviously that's a struggle that nobody wants to go through. You don't want to see your loved ones go through that.
Yeah, I'm looking through a Reddit post, and it says nothing about drugs there, just a cardiac arrest.
I would presume. I mean, I'm not going to say that it most definitively happened, but it seems implied.
So I saw a comment in the chat mentioning that Murdaugh was spending, and I kind of remember this in the trial, like $50,000 a week on drugs or some ridiculous amount of money.
Yeah.
Obviously, that's impossible. But what could have been going on is he got in with the drug dealers put him under pressure, and then he started money laundering for them.
Yes.
Yeah.
That would explain that volume of cash going through.
Yeah, because $50,000 worth of drugs is a ton of drugs. Allegedly.
They're just not that expensive.
Yeah. And he might have paid $50,000 for a bunch of pills, but it wasn't worth it. And then you go into, okay, why did he pay? Was it protection? Was it...
Or extortion, right? You're going to pay us $50,000 for $1,000 worth of drugs, or we're going to expose you.
Right.
I mean, we're talking about over $200,000 a month. Nobody pays anybody that amount of money for pills.
No, nobody.
I mean,
not even the most, significantly addicted person can take that much of opioids. That's not possible.
Yeah.
I would think extortion. I would think he was stealing in order to pay off people who were threatening him and his family. And at the point at which he couldn't pay anymore, perhaps somebody comes and, they make good on their threats. That's a very reasonable explanation.
Yeah, and if they threaten him with, you have one boy left, you take the fall, your boy lives.
Yep, that's right. People are easy to kill.
Yeah, for certain people are easy to kill. And they already, if that theory is correct, I won't imagine it happening to my family, but I can imagine the situation that would I take the fall for my nieces and nephews and everything if 2/3 of them are killed off, and somebody tells me you go to prison or we kill the rest of them? I would fucking go to prison.
And anyone who's had a child who got seriously ill knows what the answer to this is. Any parent would suffer the worst fate to save their child from that illness, right? Any parent who loved their children would suffer the worst fate to save their child from being executed by drug dealers.
Yeah. And then you have this payback for the girl, and this is the boat accident. You have a lot of people in that community who wants revenge.
The point is there's lots of alternative hypotheses for why these murders could have been committed. And to my mind, the moment you have a reasonable alternative hypothesis, you have reasonable doubt.
Yeah.
Precisely. And it was like that in the Anderson case as well. But the problem with Wisconsin is you had the Denny motion thing. So that made things a lot more complicated. I think that multiple alternate hypotheses that are as reasonable make sense. And they make more sense to
Steve, sorry, Chandler. Steve Gosney's in the chat. If you want to send him a guest invite, he's extremely knowledgeable.
Yeah,
sorry, Chandler. Go ahead.
He has an hour before an hour and a half before Excited Utterance has the stream about a dingo killed my baby. And
oh my God, we're doing that one again?
Yeah. And Excited Utterance just started a channel. She's from that imaginary island down south, and she wants to do coverage of her home turf. And I applaud that. But
almost certainly another gross miscarriage of justice, by the way. I certainly agree there.
Yeah. And I don't think Gosney, he's been at work, so he probably doesn't know anything about this.
He's probably writing an article on this right now.
Yeah. I bet he is. And immediately.
Which will turn into a book. And and reminder, hit that thumbs up. It's free, helps the channel. If you see other things I've covered,
I guess I should do that too, right?
Yeah.
I always forget. Sorry.
No worries. And The article, Pharaoh Housewife. The article just dropped on Steve's page. Yeah, and subscribe. You will see me yell at prosecutors. You will see me yell at defense lawyers. You will see me yell at the judge. But everything has the foundation of my training as I evaluate evidence, and I try to get everything down to a layman person. And I'm still learning. I'm not American. I'm still learning about U.S. laws. Especially Georgia RICO, because I've been covering the Young Thug RICO trial for months now. So I'm getting a basic understanding about the Georgia RICO Act, which is broader and vaguer. And it's the same state and the same district attorney who is doing the Trump RICO. So she will conduct 2 RICO trials, her team will at least, 2 RICO trials at the same time.
Hey, Nick, where did you send Steve the link? He can't find it.
Oh,
he's got a lot of email addresses.
Oh, there. Now he has the link.
Steve, I sent you the link on X/Twitter
On
as
X,
well,
yeah.
if you need it.
Yeah.
Whatever's more accessible to you right now.
Yeah, I've been talking a lot today. This is my 3rd stream today.
Wow, you're just marathoning.
Yeah, I began the day with the verdict watch on the... Hi, Steve.
Steve, hi.
Hi, how are you guys? It's so funny. I can't believe this is a first. Andrew says, hi. Andrew says, he said, wait a second. Andrew said to me, Steve's got so many contact or emails, or what did you say?
I've got at least 4 or 5 for you. Now, in fairness, half of them are ones that law of self-defense created for you because of American law courses and all that kind of stuff. But
Exactly. There you go. Yeah, I have to check about 5 emails. But everybody, my son laughs at me when I say I use email.
Now,
but
have
got
you
the
seen?
now.
Yeah, have you seen anything about what has been the Murdaugh case? And yeah, you have.
Well, yes. Not only is this a case, of course, I covered almost gavel to gavel. I was watching the Lawyer You Know's stream on when we're going to be on tonight at 8:00 on my Rumble channel. Lawyer You Know is going to come on and we're going to talk PI law. And so I was clicking and I saw that he was on. So yes, I did. And I listened to the affidavit and my jaw kind of hit the ground. But I will say that given my impression of the state and the SLED and the prosecution and the way they conducted everything, it kind of smelled to me like there was dirty shenanigans going on behind the scenes.
The whole time. Yeah. I had that. You know, when that SLED guy takes a witness stand at the trial and he confesses to perjuring himself before the grand jury
on the great evidence in the very his perjured testimony was the basis for the indictment.
In a just world, if you're at trial and it turns out the indictment is effed up, they would dismiss the trial because that's fruit of the poisonous tree, as far as I'm concerned. But they never do that. It's
right?
Crazy.
Exactly. No, and
the only reason you're at trial is because you got the indictment. Well, if the indictment is corrupt, you shouldn't be at trial.
The indictment it's not corrupt. It is based on false testimony. Your charging document, which is the key thing that kicks everything off, was based on flat out false testimony by that SLED agent. And I listened to a little bit of the lawyer who represented the juror, who one of the affidavits in juror, and he said, well, this is what happened. Let the chips fall where they may. And that's kind of my attitude about a lot of this, that's what should be like. If the SLED agent lied, you dismiss the indictment and let the chips fall where they may. You may have to recharge him or something, but let the chips fall where they may. Because
kind of depends on who's running the chainsaw, though, right? You don't want SLED running the chainsaw,
right?
It won't work. It won't run.
SLED was terrible. I thought from the get-go they were very bad. I do have, because I am me. Hey, Chandler, don't leave. Come back. I didn't want to run you off. I love Chandler. Anyways, I did pull out my Florida procedural book. And I was thinking, like,
did you write that one, Steve?
No, I didn't write this one. But I was looking up, okay, so how would this work in Florida? Because actually, I'm going to be teaching Florida criminal procedure for Mr. Andrew Branca and the American Law course is upcoming. And so, of course, I'm very much poring over my criminal procedures. And I was like, okay, what would happen in Florida? Well, the applicable rule is Florida Rule 3.600, grounds for new trial. And under sub B, it lists a bunch of reasons. And listen to just some of these reasons in Florida, for example. The jury received any evidence out of court other than that resulting from an authorized view of the premises. Boom, number one. Okay, here's another one. The jurors...
Why is that bad, Steve? Why is it bad for the jury to receive outside evidence outside the realm of the courtroom?
Very good question. It's because the defense is deprived of the right of confrontation, which is a constitutional right that you have to confront the witnesses against you.
It's so important. It's in the goddamn U.S. Constitution. That's how important it is.
And I'm going to have to make you put $1 in the tip jar.
Steve, I'm so glad that you came on to talk about this. So I was in chat earlier before, and I didn't know that I was going to be invited on, and I had this really specific question, and it was exactly about it. It was, what are the reasons why we might be able to get a new trial? When do we bypass appeal? And I was getting really frustrated because Nick and Larry were so absorbed. They were so absorbed in what they were reading, and so I'm so happy I got to come on and talk to you guys.
No, very good. I have more.
So curious.
I have a good. Somebody was wanting a Steve rant, and I can rant a little more. That's just one. That's just sub 2. Now take a look at the number 3. If 3 is any juror after retiring to deliberate upon the verdict separated without leave of court. I have a question about this whole male and female room situation.
That's so weird. I've never heard of that.
Never in Florida.
30 years practicing law. I've never
heard of that either. So that would be 3.
I missed that. What was that? The male and what?
Yeah, even during when they were sent back to different rooms.
Yes.
One of the rooms was mostly men, and the other was mostly women.
So they segregated them by gender to...
The county,
Wait, I'm sorry.
The county clerk went to one of these rooms much more than
right. I don't know what's going on with that, but that maybe it's a South Carolina specific thing. But here's another one. Any juror was guilty of misconduct. The prosecuting attorney was guilty of misconduct. And then we have 8, or for any other cause not due to the defendant's own fault, the defendant did not receive a fair and impartial trial. I have never heard of this type of thing coming forward in a criminal trial that I'm aware of. There's probably cases, I haven't dug and done the case. There's probably cases like this. Let me take that back. I'll take that back. I had a case with the late and not great, in fact, terrible Judge Wolf. And in his courtroom, the bailiff was massively interfering with our case. And I will say, with the authorization of the judge and the prosecutor, with a complicity, which was disgusting. But it was this good old boy home cooking BS that I could smell from a mile away at this trial. And, so that sort of thing happening, because remember the affidavit here, they're saying that the bailiff and the clerk were involved together. And I can see very much that happening with home cooking. And we're going to get this guy Murdaugh that we don't like. Oh, here we go. Look at this.
2012 South Carolina Code of Laws, Chapter 9, Offenses Against Public Justice, Section 169340.
I'm not sure this is the right one, though.
It should be 350.
Now, this is a criminal statute because I think that the clerk's interference in the jury is a criminal matter. But what I'm talking about is the motion that the Pootlian guy is doing, which is a motion for new trial. And Chandler did have a specific question, but before we get to that, it's Nick's show. I don't want to take over.
No worries. This is attempting to influence juror by written or oral communications authorized by court, not prohibited. But here comes it. If it's not authorized by the judge.
Yeah, but see, here's the problem with that. That's a South Carolina Code of Law. That's a South Carolina state law. And it's just like we have admitted perjury on the stand by the chief investigating officer to get that indictment. Was he prosecuted for perjury? He was probably given a raise and a commendation.
Steve, he was just made SLED Law Enforcement Officer of the Year.
There you go. So, and like that's ridiculous. So this is the problem: is you get this kind of backroom dealing in these small towns. Corruption is bad. And I know that there's a lot of politics. And see, I am not a person, I have no clue what the politics is involved in this. So I'm looking at it as an outsider. This kind of corruption is bad, whether it's on the defense side, the Republicans or the Democrats or any of this.
No, it's okay on the defense side.
No, but you know what I'm saying? Like politics wise, a lot of people are like, well, this is Republicans or it's Democrats, or they've got all these little reasons to short circuit the system and to play dirty. And none of those reasons are valid. You got to support a fair trial, regardless, even if it's the devil himself.
Yeah, and since it's written into the Constitution, state law really, they can apply, but it doesn't necessarily apply. If it is, as I heard from the
it's state law. Theoretically, it could apply, but it would take a prosecutor who is willing to take the case. And I didn't know that. Andrew says that the guy got Officer of the Year or something. He's an admitted perjurer on the stand.
And fabrication of evidence. He introduced shells into evidence that were, not what he said they were. I mean, it's crazy.
Yeah. And he testified to the grand jury, we found blood on his T-shirt. They hadn't even tested the T-shirt at that time. And
that's a damning bit of fact to put in front of a jury. I mean, the blood, and I don't know. What was Chandler's question though? Because I know that she had.
Oh, it's okay. I mean, I had already asked Larry, Branka, and Nick as well. I think I pretty much got the answer. It was kind of what you were explaining about the process by which you would determine, a retrial essentially, and bypassing appeals. I just wanted to understand, let's say that this goes forward, what happens next with his case?
Okay, well, I
think I understand.
Question, all right, well, it's kind of a complex, interlocking thing, and it's very procedural. And again, maybe if somebody's really interested and wants a deep dive, Chandler, maybe you should take my
criminal procedure course.
I would like that. Well, I'm just about to take the final for the constitutional law course for American law courses, and I loved that. Linda Deno is awesome. I mean, you took it, Steve, right?
Yes. Oh, I was in and out. I have them, but let's just say,
send me an email, Chandler. We'll get you signed up for criminal procedure.
Really, that would be fantastic. I would love that.
You'll believe me. You will. If you want to know criminal procedure, sign up for this class, because it will be a painful, detailed, deep dive into criminal procedure as most lawyers never even touch.
Some people don't know, but Steve, who's currently a public defender at the appellate division, he was a prosecutor. So he's seen it from both sides of the fence.
Right. And also people don't also think I have my board certification in criminal trial law, which it's not appellate law. There's an appellate certification too. And I was thinking about being double board certified, but I sat for the test just to get a preview, see what's on it. And it's exactly what I suspected. It was all about complicated timing questions. Like, okay, so you missed this deadline and there's this thing and this moving parts and calculate the deadlines and all. And I'm like, to me, I have one easy solution and that's to work ahead. And I never worry about deadlines, because I got all my stuff done ahead of time. I don't have to worry about it. So it's like, if that's my answer to all their stupid questions on their test, I'm like, I don't want that certification. But back to Chandler's question. Okay, so what is the difference? The appellate court generally looks at the law that is applied. Okay, so did the judge follow the law? And so what we're doing is a top to bottom analysis of the rulings that the judge made, and did he apply the correct legal standards? What the evidence is usually determined at the trial level. So the facts are determined at the trial level. And in fact, there's a very good case on that called the Apprendi, which means when you have a jury, the jury makes the facts, the judge makes the law. Well, appeals are generally not a check on the fact-finding function. Now, if there's absolutely zero evidence, then there's legal questions. But if there's some evidence and it's a credibility question, then that's not off the table for appellate purposes. Now, what we have here are additional facts that, if true, would show that the trial was unfair. So that is an evidentiary investigation that needs to be done. In order to have that evidentiary door opened, you file a motion that, if believed, will, if you have a file a motion that it alleges, just like what they did here, misconduct by the jurors, they then have a hearing. And this is the thing, is it's an evidentiary hearing before the judge. If additional facts are needed, sometimes the motion for new trial is based on issues of law. You got a ruling wrong or something like that. But other times it's an evidentiary question. Usually you see this in the form of my lawyer screwed up and it's an ineffective assistance of counsel charge. That's what you see a lot. And that requires an evidentiary hearing in Florida. But in this case, you're alleging juror misconduct. And that is also something that requires an evidentiary hearing. It requires the state to come on and cross, and a truth-finding function at the trial level. Once the evidence is done at the evidentiary hearing, the judge will make the ruling based on that evidentiary finding. Does that make sense?
Yeah.
It does make sense. I'm so glad that I asked, because I got 4 different lawyers to answer the question.
Yeah, post-trial evidentiary rulings are very unusual because, as Steve says, normally the trial court gets and the jury gets complete deference on all the findings of fact. So the jury's the finding of fact. Whatever decisions the judge made about admitting facts for the jury to consider are almost absent an abuse of discretion, which is a standard almost never met, is left entirely in the discretion of the trial judge. So the appellate courts, they very rarely actually hear evidence. They go by whatever evidence was presented at trial. Normally, the view of the evidence that's consistent with the verdict, guilt, in the light most favorable to the state. And they never consider anything other than that. They're only looking at issues of law. But then we have these weird cases like right now.
Well, and
I think they have applied for a stay on the appeal for these evidentiary hearings. And the reason it's not only juror misconduct, it is from the county clerk, from SLED agents, and from some jurors.
Right.
So this is I've never heard.
Well, it is out there. I mean, it's not unprecedented, but it is out there. I mean, this is one of the reasons you get a new trial. I had a case. Oh, I know what it was. In fact, it was one of my biggest victories, I will say, that I had a little tiny piece of. But the whole time I was in, there was a case. Let me see if I can get the facts real straight. The victim came in. It was a sex case, and the alleged victim, the accuser, was saying that all of these sexual things happened and was very detailed in their sexual descriptions. And the state presented it as this person was virginal, didn't have any sexual activities, had no reason, and said the explicit nature of the descriptions of the sex acts were evidence of guilt on the part of my client. Okay. It came out, and then she got on the stand and said, I've never seen anything. I've never gone anything, never dealt with this. What came out, there was a motion for new trial because after she testified to that, her best friend, who was also a witness, came forward and said she lied her ass off. We used to watch pornography together all the time. Which would explain a 14-year-old having graphic knowledge of what goes on in a sex act, right? And so there was a motion for new trial based on perjury by one of the main accuser. So it's sort of an interesting. Here's another. If you want to hear a real tricky question, look at the Glossop case out of Oklahoma, which is a death penalty case, because what happens when all of your time frames, you lose all your time frames? 2 years goes past, 5 years goes past, your appellate time frame's gone, your new motion for new trial is gone. And then new evidence that says that you're actually innocent. Maybe there's DNA evidence that gets tested and they find out that you're actually innocent.
Was this the one that you emailed me this morning?
Well, I don't know what I've emailed a whole bunch of stuff, but
you emailed me some death penalty case. I don't know which one.
No. This is one out of Oklahoma. And so here's the question for the panel and for the chat and for the listening audience. Does the procedural bar actual evidence, an evidentiary hearing on actual innocence?
Yes.
You're cheating, Andrew. You know the answer.
Yeah, because that's the entire baseline for any trial. As I've said throughout this stream, is this has nothing to do with Murdaugh. Nothing. It has to do with the process. You have to guarantee it for the absolute worst, because if you can't, then it's not guaranteed for anybody.
But I think Steve's touching on another issue, which is we have this thing called the criminal justice system. It's not the criminal fairness system.
Yeah.
It's a bureaucratic administrative system, right? And it's balancing different interests. And one of the interests may be fairness, but another interest is certainty. It's done. We're not going to have a trial go 100 years. We're going to have some procedure happen, and we're going to come to a verdict, and then you get an appeal, and there's steps in the procedure, but at some point it's done. There's finality. We're not doing this over again. And that's the problem that Steve is addressing here, where new evidence is presented, but the procedure says, listen, we already put the period on this one. It's over.
Well, and in fact, that perfect. Andrew, see, we're like of one mind here. We're the uni mind. But
now, I'm not in favor of that.
I mean, here's the other balancing interest, because I represent.
I'm a defense attorney, so
right, I get it.
Wait,
I get it.
Andrew, you're not in favor of what specifically?
If it were up to me, credible, substantial evidence consistent with innocence should always be considered. Because I think I'd rather let 100 guilty people go free than one innocent man be in prison. But I understand the system. Because people make shit up. I mean, an ex-girlfriend shows, that didn't really happen. I lied at trial 20 years later. What are you going to do? Have a new trial now? I mean, it just becomes administratively burdensome. We're balancing that against the prospect that an innocent person could be in prison. But the truth is, we accept that innocent people go to prison. Because we don't demand that proof be beyond any doubt. We demand only that proof be beyond a reasonable doubt. And by doing that, we're accepting that there are going to be cases where people who are not actually guilty beyond any doubt are nevertheless sentenced to life in prison without possibility of early release. That's a public policy decision we all agree to, whether we're affirmatively understanding that we're agreeing to it or not.
Well, there was in my death penalty debates book, which Chandler Remington actually did some editing on here.
You know, Steve, you should put my real name in there.
I know. Well, I don't want to blow your cover unless you fully. But I would.
I'm gonna get doxxed eventually. You can just I'll.
You say I'll be happy to do that in the next edition. But in there, Thomas Sowell makes an excellent point, because I was doing my research trying to figure out, and the great Thomas Sowell, probably one of the leading academics of our time, said that this is hard for people to comprehend. But
certainly the leading academic of our time.
Yes, and I did him because he is a death penalty proponent, I would say, or a critic of some of the death penalty opponents' arguments. So he had some really interesting wisdom to impart. But one of them is that there is a societally optimal amount of crime. Now, that is a hard thing for most people to comprehend, because first of all, people that work in the system, it's like that's your whole job, and your job is to eliminate crime, and 0 would be optimum crime, right? None. But that's actually not true.
You can't do that in a free society.
Exactly, because there's a counterbalancing thing of you have a constitution, you have rights, you have to respect the possibility of innocence, you have to respect the constitutional defenses, put the state to its burden. And so there is at some point at which your tyranny will rise to the point that the level of crime is suppressed to the point that the criminal prosecution itself is the crime. And
it's a gulag nation at that point.
Yeah. And you have the U.S. Constitution that guarantees those rights. We have the European Union Constitution that guarantees the rights within the European Union. And sometimes we see it, especially in former Eastern European countries, because as my chat might know, I'm still covering the Andrew Tate case in Romania, and that's $1.50, and that is still no trial date, by the way. Are we
going to talk about Tate? I got a lot to say about Tate.
Just saying that I've seen interesting things, and I will have to do an update as soon as the Dinkins trial. We are still waiting for that for the judge. It's a
Well,
bench
Frank, I
trial.
thought you were gonna.
Yes, it's a bench trial in the Dinkins trial, and he still hasn't come back. But in a bench trial, the judge takes the time he needs because he's a finder of law, finder of facts, and once he gets the verdict, he has to motivate it and navigate through every possible appeal issues. So
well, the
he
nice
might
thing about a
already-
bench trial is the judge often does write a detailed opinion about
Yeah.
how he arrived at his verdict, which you don't get from a jury, right? A jury just delivers a verdict and you don't really know how they got there. At least a judge may explain how he got there. The risk, of course, is that your life is in one man's hands.
Yeah.
And if you're a defense attorney and you're looking at a jury, you only have to convince one person there's a reasonable doubt. At least you get a hung verdict.
But in the Dinkins trial, everything is everything is against him, and it started out two days before trial started. He opted for a bench trial. The prosecution had the entire trial was supposed to be 5 weeks.
What state is this in?
Iowa.
Huh. Because in many states, the state has a right to a jury trial too, so that it's not solely up to the defendant.
Yeah, but whatever it is, it became a bench trial 2 days before the trial. So it was scheduled for 5 weeks. Then it became a bench trial, and then it was scheduled for 20 trial days. The closing arguments was on day 14. So a 5-week trial became a 2-week trial just because it became a bench trial.
Sure.
Well, just jury instructions, just jury instructions and picking a jury. A lot of our criminal protections are afforded because of the existence of this duality of the jury as the fact finder. And you follow a European, right, an inquisitorial system in Sweden, right, Napoleonic Code. So it's a whole different
civil code,
civil process, right? Not common law. Although they tend to be merging a little bit over time, it's a very different type of system than we have in the States or in any English following countries. So well, I wanted to get back one thing on the procedure, because Andrew, he knew the answer to my Glossop question, because the Supreme Court actually said, because Glossop, there was evidence that came in that said he didn't do it. But so much time had passed, they're like, but there's an institutional interest in finality.
Right.
So even evidence of actual innocence does not give him a right to a hearing where he can present that new evidence to show he's not guilty. So now here's the counter side, and I try to be fair in all things, such as death penalty debates. I try to talk about both sides. But is that
you wrote a book?
I wrote, well, this is just one. I wrote 4. I've got another one. This one is the one that we're talking about. So, but there's another thing, and that is if you say that somebody has an institutional right, an absolute right to reopen the door based on newly discovered evidence, every prisoner who's serving a life sentence is going to be filing another motion to reopen his case based on some affidavit that he got from his buddy. So, and the courts hate doing that. They hate hearing, wasting their time, so to speak, on all of the people that say, oh, I'm like him, right? Because if one guy gets out and then 100 more line up behind him and says, yes, me too, right? So
in any criminal trial, you do the whole thing, whether it's a couple days or a week or 2 weeks, and you get to the end and you instruct a jury and the jury comes back with a verdict. And whether the verdict is for you or against you, it's over. I mean, there's a sigh that now you can move on to the next job. I mean, a desire for finality is just normal for humans. We fought the fight. The fight has to end some goddamn time. It can't go on for 100 years. And of course, from an institutional perspective, you need that too, just for efficiency of administration of a criminal justice system.
Can I make a shout out to the Nick Trial Watch chat and the watchers, because I'd say this is probably the most impressive thumbs up watcher ratio that I've ever seen on any channel. And everybody's always getting scolded for not putting the thumbs up, but people should get a thumbs up for getting a thumbs up. You've got almost, what is it? I see you got 179, you've got 208 watching. That's darn impressive. So good job for all the people that are watching.
Yeah, I'm looking at individual views are a bit over 600 in total. Every 30 to 45 minutes, more or less, the entirety of the chat or the viewers exchange, except the 50 people who are always here. So we should be at 500. No, I'm just kidding. I'm perfectly happy with that amount of thumbs up. It is more than it used to be.
Yeah, very
Well,
good. Good job. Your guys are dedicated and committed, and that shows through that.
So I see some comparison between like oh, you pulled it up, Mads. Like Sweden doesn't have an inquisitional system, blah blah blah, and that's a great comment. I don't know anything about Swedish or European
I'm
criminal
not
justice
entirely
systems.
sure the difference between.
But for the Europeans, it might help to understand a criminal defense lawyer's perspective in America. I think that the prosecution should be held to the most rigorous standards possible, and the defense should be able to do whatever the fuck they want. That's my position.
Right. No, and this.
So it's not
you
balanced.
Even said something that grinded on me a little bit because Andrew, he respects good disagreement. I know, my friend Andrew. And one of the things you said was that the state had a right to X, fair trial, whatever. The state has no rights at all. That is one of those things that hits my ear and I rebel. Rights are guaranteed by the Constitution to the citizens, the individuals of our country. The state only
Can I change it to privilege?
Privilege. Oh, well, or the statutory, they have statutory privileges related to certain elements. But like the state does not have a right to remain silent, for example. There is no such. The state has no right to freedom of religion, or they have no right to anything. They have no right to anything. The rights that what the state has is generated by laws passed by our legislatures and enforced by the courts. We have what we call a negative rights-based system, in that the Constitution and the Bill of Rights is a shield against excessive state action. Now, in Europe, on the other hand, there is a more of a positive rights type movement, which tends to be considered the progressive left, this sort of thing. You have a right to housing, a right to healthcare, but we don't. That's not what rights are originally conceptualized in the United States.
Because in that path lays madness.
Yes, well, we're all in agreement here, but I'm just saying that it's a shield against government action. So when I have a right to remain silent, the state is acting on me, and I have an absolute bar. No, you can't do that, state, and here it's guaranteed. So that's just a little framework there I thought I'd bring up.
And of course, everything Steve is saying is correct. So my only point was there are some states where if the defendant says, I don't want a jury, there is no jury. That's it. The prosecution has nothing to say about it. Now it's a bench trial. But I'm not sure it's the majority of states. But in many states, if the defense says, no, I don't want a jury, the state also gets a say. And if they want a jury, then it's a jury trial. I don't know how it works in Florida.
Right. Well, there's we're going to go over this in criminal procedure and American law courses. I've already done that outline, actually. It's quite complex. The state in Florida can actually force a non-jury trial in certain cases.
No way.
Yes. But the way they do it is they take any it's a misdemeanor court, and they have to agree ahead of time that incarceration is not on the table. So the guy can't go to, if they say you can't sentence this guy to jail, it can only be probation. The state,
and a misdemeanor.
Yes, in a misdemeanor, the state can force a non-jury trial. Isn't that
interesting? So for those who don't know, I mean, it's a Swedish host here, but in America, the difference between a misdemeanor and a felony is a big deal. If you're convicted of a felony, you lose all kinds of civil rights. Your right to vote, your right to possess firearms. It becomes very difficult to get a job. It's a big deal. A misdemeanor is more than a traffic ticket, but not anything as serious as a felony conviction.
Yeah.
And when you're
in theory, over here, you still have
Well, another concept that people have a little trouble understanding, because we're such absolutists about everything. You know, I'm a free speech absolutist. I'm a right to bear arm absolutist. I'm a free whatever, and so they take these constitutional rights and they say, I am just absolutist regarding whatever my favorite constitutional right is. Well, that is actually not the way the courts generally see rights or anything in the Constitution. It tends to be a balancing thing, which was what Andrew talked about earlier. And a good example of that is the right to due process. And I use this as a little preview. We're doing a whole like a criminal procedure preview here, but the due process, like how much due process are you due when you face a traffic ticket? Can I demand a 12-person jury trial when I have a traffic ticket? And everybody would say, well, of course not. That's silly. You're just talking about money. Well, or a misdemeanor. Are you entitled to an attorney court appointed in a misdemeanor? Actually, the U.S. Supreme Court says not really. Only on felonies are you absolutely required under Gideon to be appointed a public defender, which is.
And by the way, in America, if you're convicted of a misdemeanor domestic violence offense, you lose all your gun rights for the rest of your life.
Really? Well, I'm not. I don't know about that. That's interesting. We'll talk. But then, of course, and part of where I'm going with this is death penalty debates. I am currently working on a brief that, if successful, will hold the Florida's death penalty statute unconstitutional. So that's what I'm doing right now. That's my life for the next month.
I want to do a fundraiser to get Steve a grift neck tattoo. Just grift right here across over there. Just under
how
the
much
chin.
would that cost? It depends on how elaborate the tattoo is.
I mean, I know a guy in prison who can do it pretty cheap.
Well,
you never lose your right to vote unless you are deemed not capable. So prisoners can actually vote from prison.
Oh no!
You never lose your right to vote unless you're deemed incapable.
I'm pretty sure Nicholas Cruz voted from prison, didn't he?
I don't know.
Normally in America, a convicted felon cannot vote. So,
but when he was in jail,
voting here, the rules
it was when he was awaiting
the individual states. So there's a lot of variance.
I believe it was when he was awaiting trial, so he hadn't been convicted yet. But everybody was up in arms about the fact that he could vote, which if he had the right, so he took advantage of that right.
Well, here's the question for the panel, though. In a death penalty case, how much process are you due?
All of it.
The answer gets it right. So you're going to make 100 on my test answer.
Well, I knew that, but that's because I read the book and edited it. So
Yes. Anyway,
there was something I wanted to go back to, Branka, that you were saying that I find really interesting. So if you're convicted of a misdemeanor DV charge, you lose your gun rights for the rest of your life.
Yep.
And does that happen? So I have a really big problem with that, because let's say that 90% of the people who do those things, okay, they really did that. I'm not going to analyze,
but a lot of times it's a lie.
That's what I'm trying to say. And then also women who are violent, who commit DV, they're not necessarily going to get the police. Yes, and so they're not going to get the police called by them or called on them, and
they're not held accountable because they're women,
right? And so they're going to have so they're going to have access to those. Right. Yes, and so they're going to have access to those firearms, and so who are we really protecting?
No, it's terrible, and the Supreme Court should do something about this, because you should not lose an enumerated right in the Constitution over a misdemeanor. There's no other right that we lose on that basis. And the mere fact that the federal legislature decides, oh no, we can just strip you of an enumerated right because of a misdemeanor, that's bullshit. That should not happen.
Especially because the Duluth bottle runs the whole system as far as DV.
And it's forever. It's not like you lose your gun rights for a year or 5 years. You lose it forever. It just as if you were a felon. You're a prohibited person. I just bought a couple firearms in the last couple of days, and you have to fill out this form here in the U.S., this federal form where you have to check things off. And one of them is, have you ever been convicted of a felony? Have you ever been compelled to go to a mental institution? Have you ever been convicted of a misdemeanor domestic violence crime? And if you say yes, you do not get that gun.
Oh man, that's really disturbing.
And by the way, this was terrible when it was passed, I think in 1986. I forget the exact year, but there were literally tens of thousands of men who prior to that had pled guilty to misdemeanor domestic violence because there was no punishment. It was, you threw your cell phone at your wife while you were getting divorced and having an argument, so they called it misdemeanor domestic violence, and you could fight it in court for $10,000, or you could plead guilty to the misdemeanor. No one cares about a misdemeanor. You don't lose any rights. And then retroactively, they stripped Second Amendment rights from tens of thousands of people who'd made the decision to plead to that misdemeanor when that risk was not on the table. It's horrible.
So you can take somebody's constitutional rights
retroactively.
Oh my god.
And a lot of those guys were cops. And suddenly, so they lost their careers too.
I'm really disturbed by this knowledge, but I'm glad that I know about it because maybe we can talk about it on feminism. Do you guys know Branka's coming on for an episode?
Ooh, that's going to be good. When is this going to happen?
It's going to be the last show Chandler ever does. I cautioned her against it. I said, "You don't want me on. You don't want me on. People respond very emotionally to me. It's not going to be good for your channel." But she was like, "No, come on."
Oh yeah, she's so sweet, but she doesn't know.
Actually,
she's like, look, it's a hand grenade.
Actually,
look,
no, I know. Actually, let me tell you, I know exactly what I'm getting into, and I'm very aware of how people respond to you and react to, because I see how you interact with people on Twitter, and that's exactly why I want to bring you on, because I think that you have a lot of really excellent points that are really interesting, and I think that if you were to talk to me, a woman, about them on my channel, I think that we could have a really productive conversation, and I'd really like to be able to flesh out some of your arguments, because I agree with a lot of the things that you say.
Yeah.
And I am the resident woke in the LawTube community, so I don't really care about... I mean, I can have more or less anybody on as long as we have a common subject to discuss. And me and Branka does have common subjects to discuss, and
you always say that we disagree all the time, but I don't think we disagree that much.
Not that much. On a few occasions on Twitter, we've been at it on it.
Well,
on
when
each
you're
other,
wrong,
but...
of course we disagree.
The one thing I love about Andrew is that he is as honest as you're going to find. And I respect that more than he doesn't want to shine me to like make me happy and make me feel like he's my buddy. He's going to give me his honest opinion. And it's like, and I'll give him his mind. We can disagree. He's always respectful, but people take this like they can't even debate things. They can't even, because they're insecure in themselves. And so they want everybody to sing their praises and agree with them. And it's like when somebody stands up against it, it's got to be something personal. No, maybe it's somebody just giving you an honest opinion, and they have their own worldview and their own perspective. And maybe you can grow by that. Learn by that.
I made the decision long ago. And frankly, I have the luxury, because I work for myself, that I can just tell the truth as I see it. And if it makes people uncomfortable, that's unfortunate. It's not my intent. I'm not trying to make people uncomfortable, but I'm not going to lie to make people comfortable. So
yeah, but see, yeah, I have
and
comments.
So much of
I just want to say that's
yeah.
Yes.
Just for we have a few minutes left, because then we have half an hour to do stuff like having a bite to eat and anything before Excited Utterance stream is on. So we might need a few minutes to reload. And for the
and then 8 o'clock, I'm going to have the lawyer you know on, which is Peter Tragos, and we're going to talk about civil trials and about personal injury law and about the real practice of civil law, not the Morgan Florida people PI law that you tend to hear in the slimy ambulance chase. We're going to talk about what it's really about and being truthful. So I'm really excited. Lawyer you know, 8 o'clock on my Rumble channel and YouTube if you have to go there.
Branka, do you have anything planned?
No.
No. Well, you show up when you show up, and when you get an invite and you show up. So
I mean, if you send me an invite, I'll probably show up. Whichever show, it's fine. I don't have anything planned. My evening is open.
Yeah, and Chandler, anything planned?
Yes, tomorrow I'm going to be doing a stream on my channel. It's going to be at 3 p.m. Eastern Standard Time, and I'm going to be discussing the myth of toxic masculinity.
Okay.
Oh, did you get the article?
Pretty good.
I sent you an article.
Did I get what?
I sent you an article on that just the other day. Did you get that?
Oh, did you really? That might have been an actual coincidence. I was going through my email. I realized you emailed me a couple of times, and I was about to look at it, but then I got the link from Nick. No, I just wanted to talk about how toxic masculinity is a myth. And I'm really excited to do that.
There was a really good article on that.
I'll take a look, and maybe I can include it. Yeah, that would be great.
I'm looking for, when is that going to be?
Tomorrow at 3 p.m. Eastern Standard Time.
Ooh.
Yeah.
I'm going to put that down.
Yeah, and tomorrow I'm going to meet up with David from MLS and Broken Baker, because David is in Sweden. He traveled here.
Oh, no kidding.
Because, yeah, his wife is Swedish, and they're spending some time here. So we are going to have a meetup tomorrow at a tiny ferry that goes between Helsingborg and Helsingör, and we will have food and drinks, and maybe we will record something from there.
That's
of
exciting.
sorts. So
I would love to
yeah.
see that.
Yeah.
David's
So,
good people. That'll be a fun time.
Yeah.
Yeah.
Yeah. So that is planned for me. Tomorrow, Thursday, is a continuation of the verdict watch for the Dinkins trial. I will have access to a computer, even though I will have this meetup. So if even Court TV thinks it will be at least 2 weeks before the judge reaches a verdict. So I would assume sometime next week. But I will have a verdict watch stream because I want to compare the girlfriend's testimony with DL's testimony, because there are some interesting differences there that I want to discuss with my chat and everything. So that is what's going on in the immediate future on this channel. But everybody, subscribe to these people and everything. And I will send you off to Excited Utterance. That will have a stream in 30 minutes, so you all can stretch your legs, have a whiz, and whatever you want to do in this half hour.
Thanks,
Until
Nicholas.
then,
Nice seeing you, Chandler. Nice seeing you, Steve. Well, Steve, I'm sure I'll see you again shortly. Take care, everybody. Bye-bye.
Bye.
Yeah. So thank you, everybody, for showing up. Thank you to chat for showing up. And yeah, have a nice day.
See you later.
Talk to you
Bye-bye.
later.